Today's date is January 23rd, 2017, and it's approximately 8:30 a.m. On our legal report committee, we have myself, Nate Jackson, chair. We have Commissioner Stan Norton, Commissioner Joe Clade, Commissioner Jim Galvin, and Commissioner Ivan Levy. I don't know if I pronounced that right.
Ian Levy, you got it.
Ian Levy, all right. And we got Chairman Roberts present with us this morning, and also we got a Commissioner Carl Kramer. And the staff, we have Director Shaw, Attorney Matthews, we got Jason Gilliam, and I saw Rhonda somewhere, and I think Vanessa Hudson. Did I pronounce that right? Huntsman, okay. And Joe Clade, we got Commissioner Clade. Didn't get her name.
This is Liz Goldstein. She'll be our new board attorney going forward.
Hi. Hello. And in the back, I see Bob Weaver, and I see Attorney Merkel, and I don't know the other three gentlemen.
Commissioner Lee.
Okay.
Evan Namias, also an attorney.
In the rear?
Just a visitor, sir.
Oh, okay. Well, with all that introduction, we're going to turn the meeting over to Attorney Matthews.
Good morning. We have the legal report this morning has 168 cases on it. Has everybody had an opportunity to review those?
Yes, we have.
We're happy to take any questions you might have.
I think Commissioner Norton has a few questions he'd like to ask.
Good morning. Case number 201-603-8791. That's item number 137, page 36 of 40. Just wanted to make a note, if this was the case that we carried over from the October meeting related to preferred warranty, and recognize that as a closed item.
It was.
Okay. Very good. Thank you.
Is there any more comments in reference to the report from any of the commissioners?
Commissioner Galvin here. On case 201-6052-111, 113, page 28 of 40. Very unusual case right here. I'm just trying to declare the recommendation. It says a civil penalty of $36,000, which I understand with the temporary tax to be settled by consent order of a formal hearing. Additionally, what I don't understand is the authorization to waive the attorney work product privilege. Can you explain to me what that is?
Good morning, members of the Commission. Mr. Galvin, my name is Sarah Page. I'm working as disciplinary counsel, and this is one of the cases that I've had the opportunity to work on. What I want to do in this case is release any investigation we have to the Department of Revenue due to the scale of the tags that are being issued out of this location. That investigation is a product between myself and this commission, and as my client, if you will, it is the duty of this commission to make that the decision whether they want to waive the protection over that investigation so that I can produce it to somebody else. So I wanted to make sure I had that special permission on the record before I turned it over to any other agency, just so that that's clear that that was authorized.
Once they waive it, it's gone for everybody. Right?
Yes, and once it is waived, that privilege is waived for everybody. A review of that investigation at this point doesn't have anything I would think that would be detrimental, but rather only helpful to the Department of Revenue. And this is a case due to the scale of those tags that we are still actively looking into, so we can find out more of why this is happening. As Director Shaw has pointed out to me, and we've had lots of discussion, this is often a symptom to a larger problem. So we'd like some more investigation if possible while we pursue at least the tags at this point.
All 72 tags been recovered or notified, or are you still looking for those?
They were given out to consumers. Right. There doesn't seem to be any reason that those consumers don't have those tags. Rather, our issue is why does it take you this many tags to get people titled?
If I recall correctly, the dealer has been in business for less than a year. To have such a large number of temporary tags that have, or consumers that have been issued multiple tags beyond what is eligible by statute. We just felt like it needed warranted having a closer evaluation and also having Department of Revenue look at it as well, since they are the issuing agency of temporary tags to licensed dealers. There's other aspects that they would look into.
That's all I have. Thank you.
Thank you, Commissioner.
Any more question, any other comments? Reference to the report? I don't see any, so therefore, we need a motion to adopt the report subject to the full commissioner. Do I have a motion?
Second.
Commissioner Kane made a motion to adopt the report subject to the full commission adoption. Second by Commissioner Norton. All those in favor of the motion signify by saying aye.
Aye.
Any opposed? Ayes have it, so ordered. Is there anything else?
There's no further business to come before this committee.
I need a motion to close the meeting. Do I have a second?
Second.
All those in favor of the motion signify by saying aye.
Aye.
Ayes have it, so ordered. The Motor Vehicle Commission Legal Report meeting has been closed, effective 8:35 a.m. Thank you.
That's quick, thanks.
We'll have a break before the full commission meeting starts.
January 23rd, and I call to order the regular meeting of the Tennessee Motor Vehicle Commission. Director Shaw, would you have roll call, please?
Chairman Roberts,
Here.
Commissioner Lee,
Here.
Commissioner Galvin,
Here.
Commissioner Clayton, Commissioner Fox,
Here.
Commissioner Kramer, Commissioner Jackson, Commissioner Melton,
Here.
Commissioner Murray, Commissioner Trickett,
Here.
Commissioner Norton,
Here.
Commissioner Parr, Commissioner Vaughn, Commissioner Tomaso,
Here.
Commissioner Levy, Commissioner White, Commissioner Evans.
Here.
Mr. Chairman, we have a quorum.
Commissioner Vaughn's husband, Rob, had emergency surgery over the weekend to have a stent put in for blood flow to his heart. So if you would keep Commissioner Vaughn and Rob in our thoughts and our prayers. Meeting notice has been in place. Director Shaw?
This meeting's date, time, and location have been noticed on the Tennessee Motor Vehicle Commission website, included as part of this year's meeting calendar since July 13, 2016. Additionally, the agenda for this month's meeting has been posted on the Tennessee Motor Vehicle Commission's website since January the 19th, 2017. This meeting has also been noticed on the tn.gov website.
All right, we'll need to adopt Robert's Rules of Order. I don't know what the alternative is, Director Shaw. I've never heard of an alternative.
I think this has worked well so far.
Okay.
So.
Is there a motion to adopt Robert's Rules of Order for the calendar year 2017?
Commissioner Jackson, motion to adopt the Robert Rules
Jackson,
of Order
motion
for
to adopt. and Commissioner Clayton,
2017.
seconded.
Clayton?
Do this by voice vote. All those in favor of the motion to adopt Robert's Rules of Order for calendar year 2017, say aye.
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 Those that oppose, say no. Motion carries. We will need to adapt the agenda for today's
Commissioner Jackson,
meeting.
motion to adopt the agenda for today.
Okay. Motion to adopt by Commissioner Jackson. Is there a second? Second by Commissioner Clayton.
We actually have one edit that we wanted to make to the agenda, if we can. Maybe amend that motion. We have an application for an Austin Evans salesperson. Somebody can maybe motion to amend it to include him. I'm sure he'd be appreciative.
I think we'd have to go back to Commissioner Clayton that seconded. Would you accept that amendment of adding that case? Back to Commissioner Jackson? Would you
Yes, I accept the amendment.
Okay. All right, those in favor of the amendment to the agenda and the agenda as published, by voice vote, say aye.
Aye.
Those opposed, say no. Motion carries. If you'd look at the minutes from the October 24 meeting,
Mr. Chairman, make a motion we approve the minutes.
Motion to approve.
Commissioner Jackson, second.
Commissioner Jackson seconds. Any comments, concerns about the minutes as published? Hearing none by voice vote. Those that approve the motion, those that are for the motion to approve the minutes from October 24, say aye.
Aye.
Those that oppose would say no. Hearing none, it passes unanimously. Ready to go to salesperson's appeals. First case will be from Nissan of Cleveland. Jamie Payne?
Yes, sir.
Mr. Payne?
Yes, sir.
If you'll come down, and if you brought somebody with you from the store,
Yes, sir.
you'll take the place at the podium, and the gentleman with you can stand there for a few minutes or may sit at your pleasure. Reddish. Attorney Reddish, excuse me.
I'm actually, for those who don't know, this is Liz Goldstein. She'll be our new board attorney, and she's actually offered to do these moral turpitude memos today. She actually just started last week, but I think she's ready to get her feet wet a little bit. So I'm going to turn these memos over to her.
Welcome, Ms. Goldstein.
I'm happy to be here.
Okay. Generally, the question is asked of the staff, what was the reason for denial of an application?
A review of Mr. Payne's salesperson application and judgment does reveal a conviction for a crime involving moral turpitude. In the case of Mr. Payne, the documented conviction is for theft by taking on January 24th, 2006. Mr. Payne received a sentence of 7 years. Application may be denied under TCA 5517, Section 114A1C until January of 2018.
Payne, would you explain the nature of this conviction? And
Yes, sir. Actually, it was in 2005. I went to court in 2006. I was going through a divorce, and I went to my house that I was the only one actually living there at the time, and took some stuff because I was moving out during the divorce. I decided to let her have the house, so I took my TVs and the stuff that I had bought from my house out of there, and she called and said that it was hers. So actually, they got me for taking my own property, more or less. So they got me for theft by taking over $500. That was back in. I went to court in January 2006.
are there any questions for Mr. Payne from the commission?
I have a question, Commissioner Norton. Do you have any other priors or any other convictions?
Oh, for me? No, sir, I don't.
Commissioner Jackson, let me make sure I understand. You going through a divorce,
Yes, sir.
and had the court remove you from your home, or were you still allowed to stay there at your home?
Well, we hadn't even been to court yet. I just signed the papers 2 days before to the divorce papers. So it was at the beginning of the month, the beginning of a new month, and I was moving out. So I just went. I mean, I had a key. It's not like I broke in, or I just went and took the stuff that I had bought a previous year because I thought it was mine. I mean, I'm sure that I was supposed to give her half of it maybe, but that wasn't even ordered in court. So the stuff that I took was actually my stuff, and that's what they got me for.
Mr. Tomaso, Mr. Payne, what's your current role at the dealership?
Sales.
You're currently selling cars?
No, I'm not selling cars now. That's what I was hired for. Now I do BDC work. I do a lot of calls. I move the cars around on the lot. I do anything that needs to be done. I was in the military prior, so look, I told these guys whatever I need to do to keep a job until I can get my sales license, I'll do whatever. It doesn't matter if it's clean toilets or whatever I need to do. So I just do whatever around the dealership that needs to be done right now.
Which branch of service?
Navy.
As was I.
Thank you for your service.
Questions?
I have one thing to add. Under count one on his conviction, it states that he did take United States currency, the property of Rex Harleston, scooter distributors with a value greater of $500, with the intention of depriving said owner of said property, contrary to the laws of the state of Georgia. So I just wanted to include that so everybody's aware what it says, and that's in your packet if you wish to review that.
I would also note that on the application, which this is generally a consideration factor, where the question is asked, have you previously been convicted of a felony, he did indicate in the affirmative that he had been convicted of a felony, so he was truthful.
Would the gentleman that came with you like to address the commission?
Is there one or two?
Sorry.
Is the
Go back to Mr. Payne.
I'm sorry?
two convictions?
The documents only show one conviction, I believe. Oh, okay, sorry, this was an accusation.
Wasn't any trial on that?
I'm not sure if there's a trial or not.
If I can, Rex Harrison was her father-in-law, and it was in, the apartment was in his name, so I guess that's where they get his name from.
So you're saying the money was in the apartment when you took the TVs?
Yes, sir, that was in the house, it was a house, it was duplex, yes, sir.
Whose money was it?
It was not money, it was TVs and betting. It was not any money, currency.
This is the same event we're talking about. There's one event, there's two, there was an accusation and a conviction, correct? Meaning
I didn't know about the accusation. All I know is who Rex Harrison is it's her father-in-law. I mean, it's her dad. It was my father-in-law.
I'm just letting everybody know the information we have. I'm looking at this page. Should be in your iPad if you want to review that. I'm just pointing out what the accusation was that led to the conviction, and it looks like he pled guilty. I know you asked if there's a trial, but so it looks like he pled guilty on that.
It was an accusation that he pled guilty to. Is that accurate, Mr. Payne?
I don't know about the accusation. I pled guilty to taking the stuff out of the house.
And the stuff out of the house was worth around $500. Is that what
It
you're
was
saying?
probably worth a little bit more than that. It was a couple of TVs and a bedroom suite, so it was probably, I think the charge was theft over $500, so it was probably around $1,000 is what it was, actually.
Will they charge you for 7 years for that?
Yeah, over probation, yes, sir.
Okay. Probation.
Georgia doesn't, they don't mess around, I guess.
Sir, would you like to address the commission on behalf of Mr. Payne?
Yes, I'm the UCM for the dealership, the used car sales manager. Jamie works directly under me. I just came to talk on his behalf. He's an outstanding worker, always there all the time, always does what we ask him to do. I just wanted to come just to be by his side to see what I can do to help to try to get his reinstatement.
Feel like he would be trustworthy to
Yes, I would.
sell cars to the public? And
He's done everything that we've ever asked him to do. I just, I don't ever see anything in the past 4 or 5 months I've been working with him to be untrustworthy. Like I said, he's a hard worker. He's always there early. He always does what we tell him to do. He's got great customer service. I just don't. Something that he did a long time ago, I would just hope that he wouldn't be, graded or looked at for something that you did 10, 12 years ago.
Well, the purpose of the commission hearing the appeal is to determine whether or not the applicant would be a risk to the consumers of Tennessee. In their dealing, or if they get a license and going forward. So you contend that he would not be a risk?
I don't believe so, no.
Okay.
How long has he been working for you?
For about 4 or 5 months.
4 or 5 months. And what did you do, Mr. Payne, prior to that?
I was in the restaurant business for 25 years. I had a stroke. I had a death in the family that caused me to have a stroke, and I just couldn't work 80 hours a week in the restaurant business any longer. And so I've always been in the customer service or in the service industry. So I got in the car business. Actually, I worked for Acura before Nissan. We just opened the new dealership in November or October.
Any further questions?
Chairman, I make a motion we approve his license.
Second.
I second.
We have a motion by Commissioner Fox to approve the license. I heard a second. Who was that over here? Commissioner Melton, thank you. All right, any discussion of the motion? And the motion is to grant the license to Mr. Payne. Hearing none, Chair calls for a roll call vote. Yes would be for the motion that would grant, and no, of course, would be to uphold the denial. Director Shaw?
Roberts?
Yes.
Commissioner Lee?
Yes.
Commissioner Galvin?
Yes.
Commissioner Clayton? Commissioner Fox?
Yes.
Commissioner Kramer? Commissioner Jackson?
Yes.
Commissioner Melton?
Yes.
Commissioner Trickett?
Yes.
Commissioner Norton?
Yes.
Commissioner Tomaso?
Yes.
Commissioner Levy?
Yes.
Commissioner Evans?
Yes.
Motion carries.
Okay. Your license is granted, sir, and Mr. Gillum has a form or to reapply? Is that what?
Actually, following the hearing, all of the approvals from the commission will be processed in the commission office, and they should receive their license within 10 to 14 working days.
The applicant can go to work pending the approval of
That's correct.
Pending the approval.
Yeah, because the approval is a matter of record at this point.
Thank you.
Okay, Mr.
Thank you. I appreciate it.
Congratulations. Yes, sir.
Thank you.
All right. The chair will need to recuse for the next appeal and ask Commissioner Trickett to preside over that appeal. Thank you. Thank you, gentlemen.
All right. Crystal Hill, Roberts Toyota, Columbia, Tennessee. Good morning, Ms. Hill.
Good morning.
Ms. Goldstein, can you read the...
Yes, sir.
Thanks.
A review of Ms. Hill's salesperson application and judgment does reveal a conviction for a crime involving moral turpitude. In the case of Ms. Hill, the documented conviction is for conspiracy to sell over 300 grams of Schedule I drugs. Conviction date was March 2nd, 2016. Applicant received a sentence of 8 years in a community corrections facility effective upon release from incarceration on April 15th, 2016. Application may be denied under TCA 5517-114A1C until April of 2029.
Thank you. Ms. Hill, would you like to tell us about your conviction? And
Yes, sir.
okay.
This is a case of guilty by association. My only mistake in this all was choosing the wrong man in my life. I've never sold any drugs. I dated a man that did sell drugs. He was under investigation. When they came to get him, when I got off at the doctor's office, they came and got me as well. They told me that you knew what he was doing, and ultimately we're charging you as well. That choice in man has ruined my life. I'm very embarrassed. I'm very ashamed, but I have never sold drugs. I don't deserve none of what I've been through, and I just want to add that this took place in Rutherford County, Tennessee. That is not the most honest county in Tennessee, as we all know. Things go on there that shouldn't. I feel like I was convicted of this crime. I had no evidence against me of selling any kind of drugs. I've never been caught with drugs. I've never dealt with drugs. But because the law is set up and they can do really what they want to do, this has happened. I just want y'all to know I have never had any involvement in anything he was doing, but because I chose him in my life and what he was doing, I was ultimately charged as well.
It says here, due to medical concerns, your sentence is hereby amended.
Yes, sir.
So, go ahead.
Judge Royce Taylor, honorary man, he kind of felt that I hadn't done nothing. He suspended my sentence because I was with child.
Any questions from the commissioners? I have a question, Ms. Hill. Did you, at that time, were you using drugs? Were you using cocaine personally?
No, sir.
Have you had any other charges or convictions?
No, sir.
Commissioner Levy, where is the gentleman that caused you to be convicted?
He is facing 60 years in a federal penitentiary.
Do you have any communication with him?
No, sir. My mom was very disappointed as well that this happened to me. I'm my only child. I have a college degree. I've done well in life up until choosing this man. And when this happened, she turned her back on me for a while, and she told me it's either me or him. And ultimately, I chose my mom, of course. It's a very sad situation, but it happened. And I'm just trying to recover my life.
Commissioner Lee, what have you been doing since you got out of jail?
I have been working at Roberts Toyota. I work in the internet room. I'm a business development agent.
I'd like to identify the man with you and from the dealership. Let him speak.
Yes, sir. This is the GSM at Roberts Toyota. He is my supervisor. I work under him. His name is Mr. Paul Caruana.
Sir, would you like to speak?
Absolutely. I would just like to personally vouch for Crystal. I know her. I've known her over a 5-month period now. That's my entire employment. She was employed before me, and I know her to be a person of integrity. She's shown many times that she cares about people, and I believe that there would be no risk with her dealing with the public.
Any other questions? Make a motion, we grant her license.
Commissioner Jackson, second it.
All right, we have a motion to approve and a second. Need a roll call vote, Ms. Shaw?
Commissioner Lee,
Yes.
Commissioner Galvin,
Yes.
Commissioner Clayton,
Yes.
Commissioner Fox,
Yes.
Commissioner Kramer,
Yes.
Commissioner Jackson,
Yes.
Commissioner Melton,
Yes.
Commissioner Trickett,
Yes.
Commissioner Norton,
Yes.
Commissioner Tomaso,
Yes.
Commissioner Levy,
Yes.
Commissioner Evans.
Yes.
Let the record show that Chairman Roberts recused himself, and the motion carries.
Ms. Hill, congratulations.
Thank you.
Just come back in. Richard Molina.
Morning.
Still chairman? Welcome, Mr. Molina.
Thank you.
Ms. Goldstein, would you describe the appeal, please?
A review of Mr. Molina's salesperson application and judgments does reveal a conviction for a crime involving moral turpitude. In the case of Mr. Molina, the documented conviction is for vehicular homicide and 2 counts of vehicular assault on January 6, 2012. Applicant received a sentence of 10 years with 6 months spent in incarceration and 9.5 years on probation. Applicant is currently on probation. Application may be denied under TCA 55-17-114-A1C until January of 2027.
Molina, would you describe the felony conviction to the commission, please, sir?
Yeah, I had an accident August 2010. I hit someone front-ended, had a couple of drinks way back home from work. I hit the lady head on, and I got a DUI, and then it became criminal when she passed away 3 months from a cardiac arrest. So the DA put that on me for cardiac arrest, and then they got the extra charges after 3 months of the accident.
Questions from the commission for Mr. Molina?
They suspended my license for 10 years. I've been good on probation. I just got my license back, I think, in October. I've been in good standings with the courts, with the probation officer. Instead of every month, I have a 6 month. They could just give me a call. I'm in good standings in the court. I'm a business owner. I own the car lot as well. I own the car shop. I've been in business over 6 years. So I've been.
Okay, you did own a car lot?
I own the car lot right now.
Okay.
And I own a repair shop, automotive repair shop as well. I've been in business for 6 years.
So your application is for a dealer license?
No, my application for salesman. They approved my dealer license, but they rejected the salesman license.
When was the dealer license applied for? What was the timing for that?
I think I got approved in December, sir, 2016.
This past December?
Yes, sir.
For a dealer license?
Yes.
Okay. And then
it is a LLC. My business is a LLC. So they said that the LLC gets approved, and me to be able to sell cars, I was denied because of felon.
Does, Mr. Radish, does a dealer license allow the owner of that business to sell vehicles?
If it's a sole proprietorship, they do not need a license to sell vehicles. This is actually a situation that we're actively doing rulemaking to get rid of this loophole, because currently the applicant in the case of his dealership, the applicant was an LLC, and our statutes don't allow us to deny an LLC because the owner has a felony conviction. However, our statutes do allow us to deny him a salesperson license. But I know we're getting into rulemaking a little bit later on this afternoon, but this is actually a loophole that we're trying to close.
Catch up a little bit on that. Because it's an LLC, he cannot be denied a dealer license?
That's correct. The LLC itself doesn't have a felony conviction, and LLCs are separate entities apart from their owners.
Correct to say that the LLC has a dealership license.
That's correct.
Molina himself does not have a dealership license.
Correct.
Question, Ms. Merlini, have you sold a vehicle since December, since you got your dealer license? And
I have 3 salespersons. The car lot has sold, yes.
Okay. What did you? And what was your statute? What have you been doing?
I run the repair shop.
The repair shop.
Yes, sir.
Okay.
What's the configuration? What's the configuration of your business? Is it all under one roof, separate buildings?
Yeah, it's all under the same roof, sir. Yes. It's a block of a building. It's a pretty big, probably 6,000 to 7,000 square foot.
Questions?
Commissioner Levy, in your opening statement, you said that in the accident, you hit someone from behind, and then later
No.
you said you hit the individual head-on.
No, it's
Which one was it?
Front.
Other than saying you had a couple of drinks on your way home from work, can you describe more as to what happened and how the accident occurred?
It was a two-street lane, and I was trying to pass a vehicle in front of me, merge left, and there was a curb. Didn't see that curb coming. I couldn't merge back.
I'm going to have a question for Mr. Reddish, if I could, just to clarify something. So the way the law states now, he can own a business and employ salespeople and sell cars with those salespeople now, right? Correct?
Yes, currently.
So he really doesn't have to have a salesman's license.
If he wishes to sell cars himself, he does need a salesman's license.
Sells them through the other salesman, he's legal, correct?
That's correct.
Okay, I was just verifying that.
I think that explanation is that he can hire salespeople, but he can't sell vehicles himself.
So you've been in business how long?
6 years.
6 years.
I'd like for the commission to consider narrowing its focus on approving this applicant, not to include what we're hearing about the LLCs. I appreciate what we're hearing, but I'm not sure that we're, I'm concerned that we might legislate by making a decision based on ownership of an LLC, creating a license, denial or approval. I would like for the commission to consider this based upon the felony conviction that would not allow him to have a license at time without an appeal. I hope I'm appropriate in saying that.
I understand that alcohol was involved in the accident?
I'm sorry?
I understand that alcohol was a cause or involved in the accident?
Yes, sir.
Is it just alcohol, or were drugs involved as well?
Just alcohol.
Are you currently in an alcohol treatment facility or rehabilitation?
I did it prior to, after all the case, I went to rehab, yes.
Are you still subject to alcohol testing? Random drug and alcohol testing?
Yes, sir.
Have you proved positive during your testing?
No.
Do you attend Alcoholics Anonymous meetings?
No.
Do you attend any kind of additional alcohol therapy?
No.
Do you still drink?
No.
Other questions? Did you bring anybody with you, Mr. Molina?
No, I didn't. Sorry, sir.
Upstairs. Further questions? Is there a motion to grant or deny the salesperson's license for Mr. Molina?
Chairman, I'd move that we table this until further time where we can have more discussion with legal.
Motion to table. Is there a second?
Make a recommendation also. I'd like for you to bring someone with you who can kind of vouch how you've improved over the years. Please.
I can do that.
That would help us out a lot.
Definitely, I can
Thank
do
you.
that.
Is that a second to the motion to table?
Yes, there's a second as well.
Okay. Second to table the motion. Let me remind the commission that the next meeting is Ms. Shaw in July.
April 24th, I believe.
Oh, April, yeah.
Sorry.
Skipping ahead.
Yeah. April. Third week of April, I believe it is. Discussion of the motion. No discussion. Chair calls for a roll call vote. Yes will be to table No will be not to table and continue consideration at this meeting.
It also includes the friendly amendment to, at the time of reappearance, that a character reference also be present.
We'd have to go back
Correct.
to the original motion to amend that.
I would so amend.
Okay. It's been amended to bring a character reference. Roll call vote. Ms. Shaw?
Chairman Roberts,
No?
Commissioner Lee, Commissioner Galvin,
No.
Commissioner Clayton, Commissioner Fox, Commissioner Kramer, Commissioner Jackson,
No.
Commissioner Melton,
Yes.
Commissioner Trickett,
Yes.
Commissioner Norton,
No.
Commissioner Tomaso,
Yes.
Commissioner Levy,
No.
Commissioner Evans.
Yes.
8 noes. And 5 yeses, so the motion fails to table.
Motion fails. Yes, the motion fails. We can continue consideration.
I'd like to make a motion to deny his license.
The license. Is there a second?
Second.
Orton, seconded by Commissioner Levy. Any discussion of that motion? Motion is call for a roll call vote. Yes. Yes, sir.
How much time did you serve?
About 2 months, 2.5 months.
Probation after that?
I'm still on probation.
You're still on probation?
Yes, sir. It's been since 2010. It's since 2010, about 6 years. 6, 7 years, actually, yes. 10 years of probation. It happened in 2010.
10 years on total probation?
Yes.
Misunderstood that.
Yes.
Or no speeding tickets or nothing?
No.
Just got your driver's license
I just
back?
got it back, yes.
Further discussion?
Commissioner Galvin, I just got one other question. You said you owned the company for 6 years,
Yes.
and you've been on probation for,
6, 7 years.
during the 6 years, have you ever sold a vehicle when you opened up the company?
It's a repair shop for 6 years.
It's a repair shop.
I just got my dealer license in December. It's 2016.
License when?
December 2016.
December 20?
Correct. But I've been in business for 6 years in the repair shop.
Motion is to uphold the denial. So as we go through roll call vote, a yes vote will deny the license. The no vote is simply not for that motion. The no will not grant the license. Director Shaw, roll call vote.
I have a question. If I don't want to sell cars, do I have to come back here? I'll just have my associates sell cars. I just don't want to go through this.
Or we're going to refer you back to the staff. We're in voting mode right now.
Okay.
And
Yeah, it's, okay.
I understand your question, and we'll just have to redirect you to the staff for instructions.
Okay.
Okay. Director Shaw.
Motion, if you vote yes, is to uphold the denial. Okay. Chairman Roberts. Commissioner Lee.
Oh.
Commissioner Galvin?
No.
Commissioner Clayton?
No.
Commissioner Fox?
No.
Commissioner Kramer?
No.
Commissioner Jackson?
No.
Commissioner Melton?
No.
Commissioner Trickett?
No.
Commissioner Tomaso?
No.
Commissioner Norton?
No.
Commissioner Levy?
Certainly can.
Sorry, everybody's voting no. My change. I'm yes. Yes.
Yes for the motion.
Commissioner Levy?
Yes.
Commissioner Evans?
No.
Motion fails.
Is there anyone that's got lost in the motion, concerns about how they voted? We can't change a vote, but you can make another the chair will entertain an alternative motion at any time.
Commissioner Jackson, I motion that we grant him the license.
I second that.
We had a second and a discussion. Commissioner Fox seconded, Commissioner Jackson made the motion to grant. Comments or further discussion?
Although we can't change a vote, would we be able to re-vote on a prior matter? Could I, knowing that a motion to deny the license will fail, might cause other members of the commission to change their vote on the tabling motion that was made earlier. Thus, if a second motion to table the matter was made, have a second vote on tabling the matter. Parliamentarily?
Yeah. Could you say that for me, Commissioner?
I can't say it again. I can't believe I got it right the first time.
Parliamentary, right.
I think that's a procedural question. And to entertain the same motion, if it's worded exactly the same, my question would be, of Robert's Rules of Order, does it require two-thirds?
Well, and there's also a pending motion and a second to approve the license, so let's just see how that vote goes.
Actually, that is correct. We are discussing the motion that we have now. May wind up discussing. we may get back to you on that. We might not. All right. Any questions about this motion or comments about this motion? And this motion is to grant. Yes, we'll grant the motion. A no will deny. I'm sorry. A yes is for the motion to grant, and a no will result in.
Chairman Roberts? Yes. Commissioner Lee?
No.
Commissioner Galvin?
No.
Commissioner Clayton?
Yes.
Commissioner Fox?
Yes.
Commissioner Kramer?
No.
Commissioner Jackson?
Yes.
Commissioner Melton?
No.
Commissioner Trickett?
No.
Commissioner Norton?
No.
Commissioner Tomaso?
Yes.
Commissioner Levy?
No.
Commissioner Evans?
Yes.
Six yes and 7 no.
You know, what that means is that your salesperson's license has been denied. You may reapply. There's as stated earlier, there's a meeting in April.
Okay.
Meeting every quarter.
I don't have to apply if I want, if I don't want to, right?
We haven't actually denied it, although if he wants to withdraw his application, I think we can move on. Or alternatively, Sarah.
No, that is an accurate point. I made that assumption. That's not necessarily true. If we we'll need a motion to deny.
Sarah Page actually wrote a memo for the department on this topic if you want some more clarity about. Okay.
I think y'all are doing well trying to get your motions together. I just came up here just to sit down, I needed to, but I don't think I need to at this time. And for those in the audience, I'm Tony Glanville, Chief Counsel for the Department of Commerce and Insurance Regulatory Boards Division.
Is the information that Ms. Page has relevant to this salesperson's application, or is it about the dealer license? Because we're not here to consider a dealer license.
That's what I would say. I've done some research. I think that would be relevant maybe later with the rulemaking, but I believe, correct me if I'm wrong, Tony, but at this point I think I would consider the dealer's license on its face rather than taking into consideration what our rule discussion might be later today. But that would be my stance on it. There's nothing in my research, legal research, that would necessarily influence how you would accept or deny this particular salesperson's license.
A lack of action by the commission would uphold the denial. A motion to deny, of course, would deny. So there can be closed without a motion, I suppose, and if I'd rather us give this applicant some clarity. So if the desire of the commission is to deny, the chair would like to see a motion for denial.
Mr. Chairman, I'd like to go back to Mr. Reddish's point and ask Mr. Molina if he wants to withdraw his application.
That's fine.
I mean, I'm just asking. I'm not.
I mean, I didn't know it was going to be all this trouble. Sorry. I think I've been in good standings, but I have employees. I'll just have them sell them. I'll deal with my shop.
Well, Mr. Molina, make certain that you understand that the commission has no authority to tell you to withdraw, or that's absolutely.
I understand, but you guys are seeing that I got approved for my dealer license, and now I can't get a salesman license. I mean, it was hard to get approved for a dealer license, especially getting the insurance bond. Insurance with my record, I've spent so much money, and now to come here and try to be a salesman, that's okay. I'll pass. I'm just happy I got my dealer license. Yes, sir.
Thank you very much for your time, sir.
No problem. Thank you.
Best of luck.
Take care, guys.
Okay. Michael Parker, Tigers Auto Gallery, Clarksville. Ms. Goldstein, we hear from the denial.
A review of Mr. Parker's salesperson application and judgments does reveal multiple felony convictions for crimes involving moral turpitude. In the case of Mr. Parker, the documented convictions are for aggravated burglary and forgery in 2004, which resulted in an 8-year sentence. Additionally, Mr. Parker was convicted of reckless endangerment with a deadly weapon in April of 2008, for which Mr. Parker received an additional 2 years of probation. Mr. Parker's probation was discharged in March of 2014. Application may be denied under TCA 5517-114A1C until March of 2019.
Parker, welcome to the commission, and what I just heard that stands out is the forgery part of your conviction.
Correct.
Would you address the commission and
Yes,
specifically to my question about the circumstances around your forgery?
Back in 2004, I was on drugs and alcohol at the time.
A little closer.
I was on drugs and alcohol at the time.
Yes, sir.
And I went to a rehabilitation center after that, and I forged signatures on my sister's checks at the time.
Checks written for?
$100 to cash, for
$100
cash.
cash?
Yes.
Okay. And that was to support a habit, support an addiction?
Yes.
All right. Was there another part to that felony, or was that
The other part was aggravated assault with a deadly weapon.
Aggravated assault, yeah.
Yes.
Who'd you assault?
Actually, I was in an argument with a person, and I was getting in a car, and they was coming running towards the car, and they said I tried to run them over. It was another friend, associate, at the time.
Tried to run over a friend?
I didn't try to run them over. They said that. They claimed that. Yes.
Why would you be, if you didn't do it, why would you be convicted?
At the time,
I mean, you either ran over the guy or you didn't you? Or
Well, I
did
didn't
you-
I didn't run him over. He come running towards the car, and I slammed the brakes on. His police statement was that I tried to run him over with the car, and the two witnesses said I tried to run him over.
Questions by the commission?
Yes, Commissioner Lee, under what I see here, it says you're driving under the influence.
I had a DUI, yes, sir.
Was that in the same episode?
No.
Parker, have you had a license before? It says
Yes,
change of...
yes, sir.
You have
Yes,
worked, sold cars before?
Yes, yes, sir.
How long have you sold before?
I started back in '97, so all the way up till probably about 10 years ago, maybe. 2003, 2004.
That in the same town, was that in Clarksville?
Yes, sir.
Other than the other DUI, were there any other charges? You've been convicted of anything else?
I just went through a divorce last year. I was arrested for domestic, which got dismissed. My wife, I was working at a car lot, had an affair with the business owner at the time. So they had me arrested twice for domestic, in which the charges got dismissed.
Currently in any rehabilitation, or have you had any rehabilitation?
I'm on probation right now for violating probation, for violating the COR for my ex-wife for 4 more months. As far as rehabilitation, I mean, I go to church all the time now. I speak to the teenagers and stuff about drinking and drugs. I mean, I've got 4 kids, and my oldest child is 26 and became an attorney. My other kids are teenagers, and I focus on my kids now.
Are you currently subject to any drug testing?
Yes. Yes, sir.
Have you had any failures from your drug testing?
No, sir.
Somebody here that wants to speak on your behalf?
Yes, sir. This is Tommy Slee.
Hey, I'm Thomas Lee, owner of Tigers Auto Gallery. I've known Mr. Parker now for 27 years. We went to high school together. I've worked in the judicial system for 22 years, fully aware of a lot of things that Michael's been accused of and convicted of. I contribute a lot of his problems with people that he hung out with in the past. I seen him from high school. He was a standout guy in high school, and I kind of seen him hang with the wrong people and get caught up in the wrong crowd. I'm hoping to help turn his life around. I've seen a change in him, or I wouldn't have him at the dealership detailing cars. I've been watching him for about the last 6 months. Him detailing cars, kind of how he interacts, people that come up to the dealership and talk to him. I really haven't seen any inclination that he is in that life anymore. He's with a new girlfriend now that seems to be trying to keep him straight. He's trying to get a house. He's doing a lot of things the right way. So in hopes to try to help him get his license back, to get him back on path. I work at the dealership 24 hours a day. I mean, well, not 24 hours a day, but open to close 6 days a week. So I will be there watching over him. Right now, it's just me as the salesperson at my lot. And so, having him would be a huge asset to me to be able to help, sell cars when I'm not able to be there. So.
How long has Mr. Parker been at your dealership?
6 months.
6 months.
Your name again, sir?
My name is Tommy Sallee.
I'm sorry, I didn't hear the last.
Sallee, S-A-L-L-E-E.
Okay,
correct.
sir. Questions? Chair will be looking for a motion.
Chairman, I make a motion that we approve his license.
Second.
Motion to grant, Commissioner Fox, seconded by Commissioner Cricket. Discussion of the motion. Say that I'm impressed with Mr. Salee's presentation.
appreciate it. Thank you.
Discussion, Chair calls for a roll call vote. Yes will grant, and no will not grant.
Chairman Roberts,
Yes.
Commissioner Lee,
Yes.
Commissioner Galvin,
Yes.
Commissioner Clayton,
Yes.
Commissioner Fox,
Yes.
Commissioner Kramer, Commissioner Jackson,
Yes.
Commissioner Melton,
Yes.
Commissioner Trickett,
Yes.
Commissioner Norton,
No.
Commissioner Tomaso,
Yes.
Commissioner Levy, Commissioner Evans.
Yes.
Motion carries.
Congratulations, Ms. Parker. Thank you, Mr.
Thank you for the second chance.
Thank you, Mr. Salee. Dante Oliver, Southern Auto Exchange, Smyrna. Good morning, sir. And, Mr. Oliver, you're at the podium?
Yes, sir.
Okay. Ms. Goldstein, or Mr. Reddish?
Ken, Chairman Roberts. Legal's recommendation is that Mr. Oliver's application be approved. His conviction was for possession of cocaine. However, legal doesn't believe that mere possession of cocaine would classify as a crime of moral turpitude.
Fairly new here. Wow, I've never seen one before where it's been presented to us that it should be approved. I was under the impression we only received appeals of denials.
His application was denied for the conviction of possession of cocaine. However, at this time, I would advise you that I don't believe possession of cocaine is a crime of moral turpitude. For that reason, my recommendation is that you approve this license.
In that case, the staff cannot grant without the commission hearing it. Mr. Oliver, would you describe the felony very briefly to the commission?
Yes, sir. At the age of 19, I dropped out of college, and I really didn't have any clear direction in life, and I started associating with myself with people who, I'm in control of my own decisions, but I was influenced about those around me, and I had a drug addiction, and so basically the cops had got called to a residence that I was at. I believe it was Christmas Eve of 2005, and they had seen the narcotics on the table, and so they entered, and I got arrested. That was 2005, 12 years ago, and since then I have been sober for 3 years. I am in a 12-step program in Murfreesboro. I have a 6-year-old son now who, besides God, is my main inspiration in life, and I've been at my current job for 1 year, and I'm just trying to better my my financial situation. My friend here, Mr. Ahmad Mukahal, is a very prominent business member in the community. He has influenced me to stay on the right path, and so he's here to help me, and that's why I am applying for this license, so I can do better for not just my son, but just for the community also.
Questions at this time for Mr. Oliver before we move on to his, would you be his employer, sir?
Yes, sir.
Would you step forward and
Yes, sir.
tell us a little about your
Well, I've
business?
known
and-
Mr. Oliver since I was 14 years old.
Let me get your name.
My name is Ahmad Mukahal. Yeah, I've known Mr. Oliver since he was 14 years old. We went to elementary school together, middle school together, high school together. There's no doubt in my mind that he'd be good, with the community. He's, like he said, he's just around the wrong people at the wrong time. And, he's here to make changes. He doesn't currently work with us there. He works at Taylor Farms. And when he first got out of, jail, he had asked me to come work for me. I was like, well, show me that when you work at this Taylor Farms that he's working at, give it a shot over there. I just want to see you got out of jail, okay, and just to see what kind of changes he's made, because I want to see it, too, at the same time. And he's been doing good there, whatnot, but now he wants growth, and I think he can find growth with us at the company. And that's why we're here today.
Questions for either of the gentlemen?
Make a motion that we approve the license.
Second.
approve the license by Commissioner Levy, and it was and seconded by Commissioner Galvin. Discussion of the motion. Hearing none, we'll vote on the motion. The motion is to grant. Roll call vote, Director Shaw.
Chairman Roberts.
Yes.
Commissioner Lee.
Yes.
Commissioner Galvin.
Yes.
Commissioner Clayton.
Yes.
Commissioner Fox.
Yes.
Commissioner Kramer.
Yes.
Commissioner Jackson.
Yes.
Commissioner Melton.
Yes.
Commissioner Trickett.
Yes.
Commissioner Norton.
Yes.
Commissioner Tomaso.
Yes.
Commissioner Levy. Commissioner Evans.
Yes.
Motion carries.
Congratulations, Mr. Oliver.
Thank you, guys.
Thank you. God bless you.
Kevin Mitchell. It's All Good Auto, Memphis. Ms. Goldstein.
A review of Mr. Mitchell's salesperson application and judgment does reveal a conviction for a crime involving moral turpitude. In the case of Mr. Mitchell, the documented convictions are for possession with intent to sell cocaine, marijuana, and alprazolam. Applicant received a sentence of 5 years probation on May 6th, 2014. Sorry, I can't quite make out what year that was. Application may be denied until TCA 55, under TCA 55-17-114 A1C until May of 2021. So it would have been 2011 that the conviction occurred.
Mitchell, would you describe your felony conviction?
Yes, sir. In 2011, I caught a charge of possession. I actually had my mind in the wrong perspective, trying to make easy money, which I never really tried. It was just my first time trying, and I ended up getting caught up with it. And as I received my conviction, I learned a lot in the time that I've been on probation. I went to barber school, got my barber license. I got custody of my 2 kids. I have the paperwork. I have custody of my 2 kids, and I just made a mistake that I shouldn't have made. It really cost me. So I've been at the job I have, been a groundkeeper and dealing with customer complaints. And I just want a second chance in life to try to restart my life and get everything back on track. I actually like dealing with people, and I like customer service, so I just want to go up a step. So I'm just asking y'all to grant me another chance.
Questions for Mr. Mitchell before we hear from
Commissioner Jackson.
Commissioner Jackson.
You were charged with in possession of cocaine
Yes, sir.
and marijuana.
Yes, sir.
I don't see him. What was the amount?
It wasn't a lot. It was I don't know the exact amount, sir. So I don't want to just sit here and tell you the wrong thing.
Small container, large container?
A small container. So it was like, I want to tell you 12 grams. 12 grams, and the marijuana was like a little bit over 2 ounces or something.
Were you selling it or were you for leisure?
I was doing both, sir.
You were doing both?
But I actually went to rehabilitation center to rebuild myself, and I actually passed that. I went through drug court, and I also went through probation. I come out probation in 11 months. I have never failed a drug test the whole time I've been on probation.
Was this your ever first conviction?
Yes, sir.
First time you ever?
Yes, sir. It was my first conviction.
That was in 2011?
Yes, sir.
When the incident happened? To the staff, is there any other conviction or anything in this record that you guys, when you did your research, did you find anything else other than these 2 charges?
These are the only convictions that we were provided with. If there's anything additional, then it was not provided to staff.
One more question. How did you get caught? I mean, where were you? Can you share that with me?
I was actually at the house.
You was
I was
at
actually at the house, and I think someone turned me in, or what, or shall I say, somebody turned me in. But I'm gonna be honest with you, it really was just God talking to me, because a week before I got busted, I said I was through with it. I said once I got through with it, I was through with it. I was going to try. I ain't care if I had to cut a yard or do whatever. I was through with it. It really was just God giving me, spanking me and just letting me know what I was dealing with. After that, I ended up getting me a lawn service, just trying to cut some yards. My mom helped me do that. I tried to cut some yards, and that's when I came to It's All Good. He gave me a chance. Told me just keep all the cars clean, and any customer have a complaint, just try to deal with it in the professionalest way I can.
Well, you wasn't charged with selling it.
Yes, sir.
Okay. And you still on probation for?
Yeah, I come off in 11 months.
11
My probation
months,
officer actually told me I didn't have to come back and report to her anymore till I come off. I just go up there every month and take a drug test to show that I'm still positive, to show that I'm still not doing anything.
Question, were you being drug tested?
I get drug tests every month. She actually don't even give me a date to drug test. I just go up there and take a drug test just to show her that I'm still in positive standing. I take her my check stub every week. I mean every month that I go. I take her my check stub to show her that I'm still working.
Gentleman that came with you, like to address the commission?
Yes, sir.
I'm the general manager for It's All Good Auto Sales. And not only have I had the privilege of being able to mentor Twin, I'm also a partner in a bail bond company in Memphis, in which I mentor a lot of my clients to help them improve their life. And Kevin is one of those guys. He's, like he mentioned, he has found the Lord, put the Lord back in his life. He's got 9 children. He didn't mention that. He just recently got custody of 2 older ones that now reside with him that we do have paperwork on here that less than a year ago. And life's all about second chances. And my letter that I wrote, I said I trust him with anything I have. I'm with him 8, 10, 12 hours a day, 6 days a week. He'd be no threat to any consumer. And we certainly appreciate and thank you reinstating his license.
Questions for the gentleman, either of the gentlemen?
How long has he been with you, working currently? How long?
I've been mentoring him.
No, how long has he been employed by you?
Probably a year.
Like the staff has something they want to share with us.
Well, it's a point of contention between everybody here at the table, but I think it's not something that I normally do, but I think it's relevant to know that this dealership did receive a notice of violation for unlicensed sales activity, and the applicant here was one of those persons that was cited for unlicensed sales activity. Though I think it would be a tenuous argument to deny a salesperson's license based on unlicensed activity, I think it's within the commission. It would be proper for the commission to know that in making their decision, and you all could ask questions about that, but I would like to point out that it's a notice of violation only, and it's just based on an investigator's observation, and I don't have any other information other than the notice of violation that we have in front of us. And this is something that would be presented to you all as part of the legal report earlier today, but obviously since we do that anonymously, you all would not have known about that. So from time to time, we do have notice of violations for people that are conducting unlicensed activity, and the natural reaction to that is to apply for a salesperson's license. That's a normal course around here, is for somebody to apply for a salesperson's license after they've been cited for unlicensed activity. I just wanted to let you all know that.
Sir, do you have any more unlicensed?
Sir?
Do you have any more unlicensed people at
No,
your
sir.
selling at your dealership? Okay. All right. Any further questions? Thank you for the comment.
Question from the staff. Commissioner Jackson, was Mr. Mitchell one of the ones that was cited?
Question?
Mitchell, was he one of the person that may have been cited?
Commissioner Jackson, yes. In our investigation, the dealership has been very cooperative, and all of the salespeople have admitted to the exact number of cars that they've sold. Now, again, this is something that's only in its very initial stages. There's been no formal.
Would have been the dealership would have been.
Right.
And to clarify, the only actor in this case that we've proposed any sort of civil penalty for would be the dealership itself. And this is also helpful. Other individuals who were involved in that who did not have a felony were all granted licenses or are now licensed salespeople.
Questions or comments? Is the Commission ready?
Mr. Jackson, I make a motion that we grant the license.
Second.
Motion to grant the license. Mr. Jackson, seconded by, was it Commissioner Fox? No. Oh, Commissioner Norton, excuse me. Commissioner Norton, second. Any discussion of the motion? Hearing no discussion, Chair calls for roll call vote. Yes, for the motion, will grant the license.
Chairman Roberts,
Yes.
Commissioner Lee,
Yes.
Commissioner Galvin,
Yes.
Commissioner Clayton, Commissioner Fox,
Yes.
Commissioner Kramer, Commissioner Jackson,
Yes.
Commissioner Melton,
Yes.
Commissioner Trickett,
Yes.
Commissioner Norton,
Yes.
Commissioner Tomaso,
Yes.
Commissioner Levy,
Yes.
Commissioner Evans.
Yes.
Motion carries.
Congratulations, Mr. Mitchell.
Thank you. Have a blessed day.
Ashley McKinnon, Lowry Street Motor, Smyrna. Ashley McKinnon. Not here. Would the Commission like to?
Mr.
action
Jackson,
on this.
motion that we accept the staff recommendation to deny the license.
Motion, Commissioner Jackson, to uphold the denial, seconded by Commissioner Fox. Any discussion? A vote yes will deny the license, effectively deny the license.
Chairman Roberts,
Yes.
Commissioner Lee,
Yes.
Commissioner Galvin,
Yes.
Commissioner Clayton, Commissioner Fox,
Yes.
Commissioner Kramer,
Yes.
Commissioner Jackson, Commissioner Melton,
Yes.
Commissioner Trickett,
Yes.
Commissioner Norton,
Yes.
Commissioner Tomaso,
Yes.
Commissioner Levy,
Yes.
Commissioner Evans.
Yes.
Motion carries.
Denial is upheld. Austin Evans, Nissan of Cool Springs. Mr. Evans.
Morning.
A review of Mr. Evans' salesperson application and judgments does reveal a conviction for a crime involving moral turpitude. In the case of Mr. Evans, the documented conviction is for selling of marijuana on October 2nd, 2014. Applicant received a sentence of 1 year supervised probation. Application may be denied under TCA 55-17-114-A1C until October of 2020.
Evans, would you like to describe the felony conviction that you had to the commission?
Sure. I'd like to start off by thanking each one of the commissioners present, as well as you, Mr. Chair. Essentially what happened, I was in a bad way, trying to make some money, was selling marijuana, got caught. I'm accountable for everything that I did. I've got a 3-month-old, trying to turn my life around.
What was your legitimate profession when you sold the marijuana?
Sales assistant manager at Verizon Wireless.
At where?
Verizon Wireless.
Okay.
I was there for 3 years before.
Verizon?
Verizon Wireless.
Oh, Verizon Wireless. Gotcha. Thank you. Very good. Okay. Any questions?
Who are you selling to? An associate, not a friend or anything, just somebody that I met in passing. He was caught distributing narcotics at a golf course to an undercover agent and decided to give everybody else up as well. So I got swept up in as part of that. I've completed all of my all probations, paid all fines. Everything should be closed.
Commissioner Lee, that was while you were at Verizon. What have you done from that point? Were you still with Verizon since?
No, sir. I actually was at the dealership in sales. My license was declined, so I was actually moved to service to sales liaison. I'm working in the service department now. I handle everything that's owed in the back end of a deal as far as accessories, any dent repairs, paint repairs, anything like that. I make sure that gets completed upon purchase.
How long have you worked at the dealership?
It'll be a year in May.
Would one of the gentlemen that came with Mr. Evans like to address the commission?
Mr. Tom Woods.
Mr. Woods?
Yes.
Welcome, sir.
Yes, thank you. I'm the salesman, one of the sales managers at Nissan Cool Springs. I've worked with Austin since about June of this past year. I've seen his work he's our liaison between our customers and putting their accessories on the vehicles, and Austin's been outstanding. It's a very touchy situation where the customer has purchased a vehicle and they have to have those items installed in a timely manner. Austin does an awesome job with our customers. He's very good with his newborn baby, too, as well. And so we're just excited to have him as part of our team. Thank you.
Second gentleman?
Thank you, sir.
Or you'd be the third gentleman, but...
Third gentleman. And I don't work in the car business. My name is Charlie Gravatt, and I am the future father-in-law of Austin Evans. Him and my daughter have been in a relationship for 2 years. I have a 3-month-old granddaughter, which Austin is a father. And I believe my daughter has a lot to do with Austin have turning his life around. I am a retired law enforcement officer, 32 years, retired from DEA 4 years ago, and I can assure you if Austin was still involved in that business, he wouldn't have anything to do with my daughter. He's at my house every day. My wife is the primary caregiver for the baby while Austin and Katie are at work, so we see him every day. We know what he's doing. We have keys to their house, a house that they bought back in August. We go in and out of their house daily, even when they're not there. So I can assure you that Austin is way past this. This was some decisions that he made when he was 18, 19 years old that I think if you'd ask him, he was some terrible decisions. And I can assure this, also, just to let you guys know, I hold 2 licenses from the Department of Commerce as a private investigator and as a security officer, so I understand the due diligence that your staff does in looking at this stuff. So I have been here before at the other commissions talking about some of my guards, and so I'm the head of security for UBS now since I retired from DEA. But I can assure you Austin that part of his life is over, and he will, if you give him the chance, will make you proud. Thank you.
Mr. Evans, I'm not sure my father-in-law would have come with me. Any questions for any of the 3 gentlemen, or Mr. Evans specifically?
Chairman, I'd make a motion that we approve.
I second it.
We have a motion to approve the license. Commissioner Lee, seconded by Commissioner Melton. Is there discussion of the motion? Chair hears no concerns or discussion. We'll call for roll call vote. Yes, we'll grant the license. No, we'll be right back where we were when they got here. Director Shaw.
Chairman Roberts?
Yes.
Commissioner Lee?
Yes.
Commissioner Galvin?
Yes.
Commissioner Clayton? Yes. Commissioner Fox?
Yes.
Commissioner Kramer?
Yes.
Commissioner Jackson?
Yes.
Commissioner Melton?
Yes.
Commissioner Trickett?
Yes.
Commissioner Norton?
Yes.
Commissioner Tomaso?
Yes.
Commissioner Levy?
Yes.
Commissioner Evans?
Yes.
Motion carries.
Thank you, gentlemen, and Ms. Melton.
Miss any cases, Ms. Shaw or Jason?
That's all that we have on the salesperson's appeals.
I need a break.
I make a recommendation, and I don't know if this is offline or whatever, but I would like to see or recommend, if we could, I've been up here a year and I see people get their license granted and not granted, but I would like to see people that got their license granted, if we can go back a year or two and see if they're still at the dealership. That just gives me leverage to say, hey, we're really doing a good job here, and our work is being done properly, because we don't know after they leave if they're going to be gone in 3 months, 4 months, if we made the right decision. Is there any way at all that we could see or track that to give us some feedback and say, hey, this board is really doing a good job? Just your recommendation. Thank
I'm
you.
sure we can gather some data and do a recidivism rate for you, so that you can see if they remain at the existing dealership. If they transfer, we can go back for a few years and gather that data.
Had that same thought, and when I started on the commission, I don't think we had that ability. We might have the ability now.
We have greater ability now. The core system kicked off in December, so our numbers it'll be easier for us to track now than it would have been before.
Information derived would need to be fine-tuned, because is the question how many are still in the business, or how many got back into trouble again? So that would be, you have two different questions there.
Well, as far as the recidivism and the way that it connects to the correctional aspects or the Department of Corrections, that's going to be a little bit more difficult for us to gather based on our limited capability and our limited authority to access those records. But we can gather to tell you if they are still at the dealership that appeared with them. That shouldn't be really complicated for us to do, to determine if they still have an active license, if they're still with that dealership, and if there's been any disciplinaries in that period of time. We should be able to gather that information.
Percentage-wise, I mean, it just makes my job better, and I'm making the right decision, and it just helps all of us, I think.
Might want to see who is still licensed and if there are any complaints on the down to. Okay, on that, back to the break. Did anyone still want the break? We do. We'll reconvene in 10 minutes. Next item on the agenda is the Director's Report by Ms. Shaw. Director Shaw.
Thank you, Mr. Chairman. In December of 2016, the Motor Vehicle Commission brought its online services live after a long, diligent effort. Those service types currently available include annual sales reporting, which all dealers have been notified of their entity number, and they've all been notified at one time, and we would encourage you to do your annual sales reporting online. The initial motor vehicle dealer applications are also available, salesman and representative applications, and renewals for each of these transaction types. Licensees may also submit some types of duplicate certificate requests and salesman and representative terminations. As you're aware, when a salesperson leaves your dealership, you have historically notified us by either a letter or returning that license back to us. We now have that capability to submit that information electronically, and I would highly encourage you to do that, especially if you've got a salesperson that's left you that you no longer want to be responsible for. There was a lot of effort put into the system development to make sure that the salesperson or the representative is properly associated in a relationship with a salesperson, with a motor vehicle dealer, or a manufacturer. So what that means, if the person is still affiliated with your dealership and you have not submitted the termination or the cancellation, they will not be able to license at another dealership until such time that notification comes in, or they call us and we break the relationship manually. So it would be very helpful to us if you could go online and do that. Future phases of the core Versa online system will include initial applications for manufacturers, RV dealers, and dismantler recyclers. Those transactions are not yet available online. Salesperson transfers and reinstatements. When a salesperson moves from one dealership to another dealership, we currently have the capability for you to notify us to break the relationship, and then they can reapply. But we have another little transaction, which is actually a transfer. IT is currently working to make that a seamless transition. Right now, we're having to handle it through a manual process. Other useful transactions related to changes in a business location or operational information. So those are change of name, change of organizational structure. So those things were not on the priority list of the go live, but they are all being worked on. We've experienced an encouraging adoption rate thus far and appreciate the support of our commission members who have helped to bring these services online and the willingness of our industry partners who have generously promoted the services through their membership and publications. We have been live with these services, and as of Friday of last week, we had 13.3% of all dealer licensees set up their initial online account. So for 3 weeks activity, I think we're making progress. Additionally, we are approaching or preparing for the fiscal year end, which is actually in June. In discussions with the chairman, we have moved forward with preparing for the audit committee and audit committee review. And hopefully we will be having a meeting in March, a committee meeting to present numbers for the fiscal year end, and that'll position us for the new fiscal year, which begins July 1. Since the last commission meeting in October 2016, the following activities have occurred. We have opened 59 new dealers. We have a total of 3,792 dealers. We have 34 applications in process, 132 manufacturer distributor application or dealers, manufacturers, 33 auctions, 618 representatives, 16,800 salesperson, 271 dismantlers, 31 RV dealers, and 61 RV manufacturers. We have issued 10 motor vehicle show permits with associated revenues of $2,000. We have opened 145 complaints and closed 162. The annual sales reporting is currently underway for this cycle, and the deadline is February the 15th. Just a note for anyone that you may encounter who reports late, you can report online. That is connected to the county clerk's office this year. And on February 16th, the late penalty will be assessed, and they will be able to pay that late penalty online as well. On our performance metrics, this is a new addition to the report because we are measured on metric standards within the department. The dealer applications, our baseline metric is to have it completed within 22.81 days, and we're actually completing it at this point at 21.55 days, and that's based on a cumulative average, so we're at 105%. Our salesperson applications, our baseline metric is 7.5 days. Our actual is 5.31 days, and that's based on a cumulative average. We're at 140%. And then on compliance, the compliance, there's one metric for the department and one for commission or board-run programs. We set our metric higher than what the baseline metric was. So the baseline metric was 91%, action taken within 180 days. With that metric, we're at 98%. And with the departmental metric, which is still meeting all stretch goals, we are at 95.3% with action being taken within 165 days. Nimvitas, the revenues collected for Nimvitas, which is the construction of the salvage system, we have collected a total of $8,000 since October 2016. And in disciplinary action from October to December 2016, we've collected $63,500. And as of the Friday, when I checked, we had more than 500 users who had signed up for our new online services. Mr. Chairman, that concludes my report.
Any questions about the reports of Ms. Shaw? Is there a motion to approve the director's report?
Commissioner Jackson, motion to adopt the director's report.
Approve the report by Commissioner Jackson, seconded by Commissioner Fox. Hearing no concerns, by voice vote, to approve the report, we would say yes, and to not approve would be no. All those in favor of the motion to approve the report, say aye.
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 Those opposed, say no. Motion carries. I thought I'd change it up. Okay, Mr. Reddish, legal report?
Okay. Report has 168 cases on it. Has everybody had an opportunity to review this quarter's legal report, and does anybody have any questions? Either Sarah or I can answer for you.
Jackson, motion that we adopt the legal report.
Motion to approve the legal report, Commissioner Jackson, seconded by Commissioner Galvin. Any discussions or concerns? Those that are for the motion to approve the legal report, say aye.
Aye.
Those opposed, say no. Report's approved. Who has the legislative?
Chairman, as one of the entries on the legal report, I have an order I need you to sign.
Chairman, as you're aware, the legislative session has begun in the great state of Tennessee one more time. At this point, the bill, or there is a single bill that I wanted to note and bring to the Commission's attention, and it is a bill involving motorcycle dealers. The department, and I will be monitoring this particular bill, which at this point it's known as House Bill 19, and it would authorize temporary sales off-site of the motorcycle dealers. So I did want to bring that to your attention, and obviously other bills are still coming in at this time, but we're still early in session, so I just wanted to present that for your information.
Do we need to approve that report?
We do not. This is informational.
Move to the committee reports. The Rules Committee will meet at 12 noon today, and on that agenda are
On the agenda for the Rules Committee, we have additional edits that the legal department has worked on in reference to the 6633 rule we discussed last quarter. And today, before the full commission, we have two rules to propose, those being the dealership application rule and the temporary tag log rule, both of which were approved by committee in October.
The temporary tag, some of you may remember that on the temporary tag rule or discussion that we had that went into committee was the organizational structure of how a temporary tag log was maintained, and also being aware that with the Department of Revenue creating an electronic system, that would make a little bit of a difference and a change in the way that those records are maintained. And so this particular rule and language, which Mr. Reddish can present to you, would address the the proper maintenance of the electronic and the manual kept records to add clarification for the dealers and for the enforcement side. It was approved to move to the full commission for approval out of the Rules Committee.
Does everyone know who's on the Rules Committee? Do we need to go back through that, Director Shaw?
Rules Committee is chaired by Commissioner Vaughn, Karn White, Commissioner White, Commissioner Lee, Commissioner Fox, Commissioner Murray, and then Chairman Roberts at large.
Audit Committee will be meeting, I think we stated earlier, will
That's correct.
by those who are appointed to that committee.
Yes, we have had a verbal notification of each person at this point, so would you like me to? The Audit Committee will be chaired by Commissioner Clayton. The other members will be Commissioner Parr, Commissioner Melton, and then Chairman Roberts, at-large member.
Approval for these reports, for committee reports.
Do not, unless you're prepared to go ahead and start the rulemaking process on these proposed rules.
New business, Director Shaw.
I think and we're getting a little disconnected here, but we'll catch up. That's okay. On the rules that were approved to move to the full commission, we will need to bring that to vote to the full commission with the particular language in order for it to move forward. Matt, would you like to?
Sure. You ready to begin that? As I mentioned, we had two rules that were approved in committee in October, and these should be in your packet. And I'm just going to go ahead and read through the changes that we're proposing to make to our rules. The first change will be in the table of contents, Rule 0960-01-.08. Currently, that reads dealer applications, and I'm just going to propose that we strike the word dealer and make this rule only about applications in general. And then the following amendments to the rules. Rule 0960-01-.08. Dealer applications is amended by adding paragraph 4, so as amended, paragraph 4 shall read, the Commission may deny any applicant for a license if any manager, director, or owner of 5% interest or greater of the applicant could be denied licensure as an individual pursuant to Tennessee Code Annotated Section 5517-114. And Rule 0960-01-.11, inspection of business records is amended by adding new paragraphs. That should only read 4, so we'll need to strike the and 5 to the rule. So as amended, paragraph 4 shall read, all motor vehicle and recreational vehicle dealers shall maintain a record of all temporary tags acquired during the preceding 18 months. All temporary tags shall be issued, sold to dealers, or voided in numerical order in the same sequence they were received. All temporary tags shall be recorded in a temporary tag log in the order in which they were issued, sold to another dealer, or voided. This rule shall not apply to any temporary tag or temporary tag log that is automatically generated from a state-operated system or database.
Comments or question from the Commission?
I have one question.
Yep.
On the dealer application on the 5% or interest greater, when will that go into effect?
So if these rules are proposed today and adopted by the full commission, we'll have an internal process for the Department of Commerce and Insurance to sign off on all the rules. They'll go to the AG's office to make sure that these rules are constitutional. After that, they'll go to the governor's office for sign-off, and then they'll return again to the AG's office for final approval. Then they're posted with the Secretary of State for 90 days. I'd estimate 4 to 6 months before, probably closer to 6 months before these could become fully implemented.
I ask if it would have bear relevance to the case we heard today. So I'm
Yes, it would.
assuming that it bears no relevance to that case. It wouldn't apply.
It would not.
Yeah.
I think that case is a good example of why we want a rule like this to avoid those situations going forward.
Mr. Roach, can you clarify the rule for me, please? So we're talking about an application for dealer license.
Correct.
And it states that the application can be denied if any manager, director, or owner, that's a bucket of 3 combinations there. If any of those people have a financial interest of more than 5% or greater?
That's correct. Currently, our dealership application requires dealerships to disclose anybody who owns more than 5% of the dealership. So we're already collecting this information, so it shouldn't be any additional burden on the dealerships because this is already information that we collect. And basically what this rule is going to do is that anybody who could be denied as an individual, as a salesperson, if you're also an owner of a dealership of more than 5%, then this would reserve for the commission the right to deny that dealership's application.
They currently list all of their managers and directors, and would they even have any managers or directors when they're first applying for the license?
I don't believe it currently lists managers.
They
or
actually
directors.
list any owner who owns more than 5%.
A lot of that information is posted with the Secretary of State's office in their business or corporate filings. So that's his information that we will routinely look up on dealerships, I believe. Although I don't believe
I'm curious as to why the positions are called out when the overriding factor is the 5% ownership. I mean, why would it be simple to just state that any person? Because I find the language of manager, director to be confusing, and it means different things to different people.
There could be, I believe what we're trying to address is there could be a situation where we have a known individual. For those who, well, I probably shouldn't bring up a specific example. You could have a situation where we've had a salesperson who we know is a bad actor, and we know that the dealership wants to bring them on as a manager. So perhaps you want to get around this by saying, I'm not going to own the dealership, my daughter's going to own it, and I'm just going to be the general manager there, so I have no ownership interest, so under this rule, you can't deny our dealership. Situations like that, I believe, is what we're trying to head off with this.
So the key is not the 5%. By your application process, they clearly have to identify who would own the 5%, but through the other information that's available to you, if there was a manager or director listed on other applications or documents, you'd still be able to deny them.
That's correct.
There's also, it connects to the grounds for denial, suspension, or revocation, which is where that language came from. The 5% comes from the application process. So when you apply under the statutory requirements, you have to disclose anyone who owns more than 5%. And then under grounds for denial, suspension, or revocation of a license, it says the applicant or license holder was previously a partner, stockholder, director, or officer controlling or managing a partnership or corporation whose license issued under this part was revoked for cause and never reissued, or was suspended for cause and the termination of the suspension had not been terminated. So it brings both of those elements together.
This does not address post-application, post-approval changes, correct?
No, but if we discover somebody doing bad acts post-approval, we can always use the current statute we have in place to try to put a penalty on them or retroactively go after the license. It's just a lot more difficult to take somebody's license after it's been approved because they have a property right. So this would just give us some leeway when we get information indicating we have a bad, potentially bad situation coming up, that we can look into it further. I mean, the commission has wide authority to collect information from their applicants. I mean, we could potentially add a question to the dealership application that we currently have, requesting that they disclose any known managers or directors, if you think that's something that might be helpful.
It seems open to loophole. I mean, you could have a plan in place, obfuscate that plan until you're approved, and then make change afterwards.
Good.
Okay.
The current language says that manager or director, but my understanding, Ms. Shaw, is the current application does not ask for that information, correct?
The current application will ask for the managing partner. It will ask for anyone who owns more than 5%, and they will identify themselves as the president, the manager, the vice president, depending on what the organizational structure is. That initial information is collected, and they also submit a copy of their charter or their articles of incorporation from the Secretary of State's office, and we do reference the records at the Secretary of State's office as well.
Public comment in this part, Mr. Reddish. Public comment. Not necessary. Okay. Which action do you request?
A motion to adopt this rule by the full commission for proposal to send to the Attorney General's office.
Motion, Commissioner Clayton, seconded by Commissioner Lee. Discussion of the motion. Roll call vote. Those for the motion to approve the rule would say yes. The alternative is no. Director Shaw.
Chairman Roberts,
Yes.
Commissioner Lee,
Yes.
Commissioner Galvin,
Yes.
Commissioner Clayton, Commissioner Fox, Commissioner Kramer, Commissioner Jackson, Commissioner Melton,
Yes.
Commissioner Trickett,
Yes.
Commissioner Norton,
Yes.
Commissioner Tomaso,
Abstain?
Commissioner Levy,
Yes.
Commissioner Evans. Motion carries.
Next, I have a series of questions that the commission will need to answer, and I've prepared responses for those who have been through the rulemaking process. I'm sure you're familiar with what I'm speaking of. It's just going to take a few minutes, and this information should be in your documents as well if you wish to follow along. And then after I read these addendums and questions, we'll need another motion to adopt these and a roll call vote on that. Pursuant to Tennessee Code Annotated Section 4-5-401 through 4-5-404, prior to initiating the rulemaking process, all agencies shall conduct a review of whether proposed rule or rules affect small businesses. Question 1, the type or types of small business and identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule. Answer. There are approximately 3,700 licensed motor vehicle and recreational vehicle dealers in Tennessee that will be substantially impacted by these rules. For the dealership applicant rule, there will be no new costs because this information is already required for disclosure on applications. The industry as a whole should benefit due to removal of a loophole that permits bad actors to continue operation in the state of Tennessee by hiding behind a corporate structure. For new record-keeping requirements, there are no expected costs for dealers to implement new record-keeping techniques. Question 2. The projected reporting, record-keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skill necessary for preparation of the report or record. Answer. The new recordation requirements of temporary tags will assist dealers in ensuring that they are issuing tags in accordance to the law and not issuing more than 2 tags on any one transaction. Further, it will assist investigators in auditing temporary tags for compliance. This rule should not require any new professional skills necessary for preparation of the records. There will be no required additional disclosures for corporate dealer applicants, and thus no additional costs involved. Question, a statement of the probable effect on impacted small businesses and consumers. Answer, small businesses may have to amend their record keeping of temporary tag logs. Consumers will be positively impacted by deterring fraudulent and other illegal activities of dealers regarding the legal issuance of temporary tags, and also by curbing persons attempting to obtain a motor vehicle dealer license as an ancillary business in order to perpetrate fraud upon consumers. Small businesses owned by bad actors will be negatively affected by the rule on corporate ownership denial rights. Consumers will be greatly impacted in a positive way by reducing the number of dealerships owned by individuals looking to take advantage of unsuspecting buyers. Question 4. A description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rule that may exist, and to what extent the alternative means might be less burdensome to small businesses. Answer. The Commission believes that these changes are not burdensome, intrusive, or costly, and as such, there do not appear to be any alternatives that would reasonably be expected to be less burdensome. Question 5. A comparison of the proposed rule with any federal or state counterparts. Other commissions, such as the Tennessee Athletic Commission, already have similar rules for corporate applicants. There are no known federal counterparts to these rules. Question 6. Analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rule. Answer. Exemption from these rules would not be expected to be beneficial for small businesses because these rules should have a net positive benefit for all law-abiding Tennessee Motor Vehicle Commission licensees in the state. Next, we have the impact on local governments. Pursuant to Tennessee Code Annotated 4-5-220 and 4-5-228, any rule proposed to be promulgated shall state in simple declarative sentence, without additional comments to the merits of the policy of the rule or regulation, whether the rule or regulation may have a projected impact on local governments. Answer. This rule will not have a projected impact on local governments. And finally, I have the regulatory flexibility analysis. Each agency shall employ a regulatory flexibility analysis utilizing regulatory methods that accomplish the objectives of applicable statutes while minimizing any adverse impact on small businesses. The agency shall consider, but not be limited to, each of the following methods of reducing the impact of the proposed rule on small businesses while remaining consistent with health, safety, and well-being. Question 1. The extent this rule may overlap, duplicate, or conflict with other federal, state, and local governmental rules. Answer. There will be no overlap, duplication, or conflict with other federal, state, or local governmental rules. Question 2. Clarity, conciseness, and lack of ambiguity in the rule. These rules are clear in purpose and in intended execution. These rules work to reduce ambiguity in the current rule structure by eliminating loopholes and clearly defining record-keeping processes to ensure accurate temporary tag logs. Question 3. The establishment of flexible compliance and reporting requirements for small businesses. Answer. These rules do create new compliance requirements in regard to temporary tags by defining how a temporary tag log will be maintained and in what order temporary tags will be issued. There will be no new compliance or reporting requirements associated with the corporate dealer application rule because there are no new disclosures required on the part of the dealer. Question 4. The establishment of friendly schedules or deadlines for compliance and reporting requirements for small businesses. Answer. These new temporary tag log and temporary tag issuance standards will not be overly burdensome on small business. Therefore, there is no need for a friendlier schedule or deadline. There will be no new compliance or reporting requirements associated with the corporate dealer application rule because there are no new disclosures required on the part of the dealer. Question 5. The consolidation or simplification of compliance or reporting requirements for small businesses. Answer. This rule will simplify the temporary tag issuance and recordation requirements by providing unambiguous standards for dealerships to follow. Question 6. The establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule. Answer. These rules do create some operational and design standards for licensees who issue temporary tags. However, they will be for the benefit of small businesses by allowing the business to keep a more organized record and should reduce the amount of time licensees spend working with state regulators. Question 7. The unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. Answer. The rule on corporate dealership applicants does create a barrier to entry for known bad actors. However, this will reduce costs associated with companies involving repeat bad actors and improve the motor vehicle buying experience for the public. Temporary tag rules will not create any barrier to entry, stifle entrepreneurial activity, curb innovation, or increase costs.
Comment on the rules? Approval of the review?
Yes, we need a motion to approve all three of those statements.
3 separate motions, Matthew?
I believe we can do it on one motion.
Okay.
Is there a motion to approve? Mr. Clayton, motion to approve. Second by Commissioner Norton. Discussion? Roll call, yes, to approve the motion.
Chairman Roberts?
Yes.
Commissioner Lee?
Yes.
Commissioner Galvin?
Yes.
Commissioner Clayton? Commissioner Fox?
Yes.
Commissioner Kramer? Commissioner Jackson? Commissioner Melton?
Yes.
Commissioner Trickett?
Yes.
Commissioner Norton?
Yes.
Commissioner Tomaso?
Yes.
Commissioner Levy?
Yes.
Commissioner Evans?
Yes.
Motion carries.
Further, Mr. Reddish?
Not at this time.
Now we're ready for new business. Paul?
I would ask our attorney, Matthew Reddish, to give you an overview of the new surety bond form for the recreational vehicles dealers.
As you may be aware, we have the new Recreational Vehicle Dealer Franchise Act went into effect at the beginning of this year. And as such, we have created a new dealer bond form specifically for recreational vehicle dealers. This exactly mirrors our current bond form that we approved last year, except I've changed the statutory provisions to cite the correct recreational vehicle law. And then, obviously, I've removed everywhere it said motor vehicle dealer and replaced that with recreational vehicle dealer.
Have an example?
Yeah, it should be on your iPad.
Number 15 on your iPad.
Labeled recreational vehicle dealer surety bond.
Sorry, you said this is supposed to mimic the motor vehicle dealer bond.
That's correct. The language should almost exactly mirror what our current motor vehicle bond states. We're just going to have it, because we've redefined it so recreational vehicle is something different from a motor vehicle dealer. We thought it best to create a surety bond form that adheres to that difference.
So in the first sentence, a recreational vehicle dealer as defined in Tennessee Code annotated 55-17-40110 as principal owns and holds or intends to obtain licensure to operate as a motor vehicle dealer, or should that read?
That should read recreational.
Recreational vehicle dealer.
Thank you for catching that.
Need to amend this form to reflect recreational vehicle dealer as opposed to.
I think we can motion to amend that.
Opted as amended.
That would work also.
Levy made a motion to adopt the form with the amendment, or with the change, from motor vehicle dealer to recreational vehicle dealer. Is that accurate?
Correct.
Question of the motion. Favor of the motion will be yes, and opposed to the motion will be no. Director Shaw?
Chairman Roberts?
Yes.
Commissioner Lee?
Yes.
Commissioner Galvin?
Yes.
Commissioner Clayton? Yes. Commissioner Fox?
Yes.
Commissioner Kramer? Yes. Commissioner Jackson? Commissioner Melton?
Yes.
Commissioner Trickett?
Yes.
Commissioner Norton?
Yes.
Commissioner Tomaso?
Yes.
Commissioner Levy?
Yes.
Commissioner Evans?
Yes.
Motion carries.
Further, Director Shaw, on the new business?
We have nothing more under new business.
Not old business.
No old business.
No old business. Item is adjournment. Would there be a motion to adjourn? Mr. Norton, seconded by Commissioner Melton. Those in favor of adjournment, say aye. Aye. Those who want to stay around, say no. Thank you very much.
Rules Committee members will need to stay around. We have one additional, the committee will need to discuss through. Red book that you have, there is an agenda for this Rules Committee meeting, and it does include a roll call and the agenda and the approved minutes.
We've got a red light. Thank you.
I'm sorry, y'all. That's okay. Over
prepared.
Yeah. I got it.
Dealership facilities.
Hold on just a second. I'll give you a copy. All you have is the statutes. These are the rules.
Explain why I couldn't.
It does have that. It does have license by this commission.
Chairman, we're ready whenever you are.
Call to order the meeting of the Motor Vehicle Commission Rules Committee for January the 23rd, 2017. On the committee, today we have Commissioner Layton, Commissioner Christopher Lee, Commissioner Ronnie Fox, and Ed Roberts, who is filling in his chair for Commissioner Vaughn. Or does that suffice?
I think that will suffice for the roll call. We do need to go ahead and read the meeting notice as well. This meeting's date, time, and location have been noticed on the Tennessee Motor Vehicle Commission website, included as part of this year's meeting calendar since July 13, 2016. Additionally, the agenda for this month's meeting has been posted on the Tennessee Motor Vehicle Commission's website since January 19, 2017. This meeting has also been noticed on the tn.gov website.
We'd like to adopt the agenda for this meeting.
So moved.
Commissioner Lee, seconded by Commissioner Fox. All those in favor of adopting the agenda, say aye. Aye. Those that oppose, say no. If you look at the minutes from October 24th, 2016, the last Rules Committee approve those or to amend those. Fox made the motion, Commissioner Clayton seconded. Those in favor of the motion to approve the minutes from October 24, 2016, say aye. Aye. Those opposed, say no. Motion carries. Okay.
Thank you, Chairman. In our previous Rule Committee meeting, we had proposed some rules to help us enforce Tennessee Code Annotated 5517-129, also known as our 6633 distinction rule. And I believe the concerns was that the rule that we wrote would be too complicated to enforce, and we were asked to draft some new language. So that is what you should be presented with currently. Did everybody get a copy of that? So the changes that legal's proposing on this rule, I'm just go ahead and read the rule, and I'll explain it as I go. So all motor vehicle dealers or recreational vehicle dealers who are operating an additional business at the dealership in accordance with TCA 5517-129 shall, upon written request by the commission or its agent, I think it's important to point out here that what this is more or less going to do is that when staff or the commission has a concern about a particular dealership, we will issue this request to the dealership. So this isn't a proactive, we won't be out, necessarily our inspectors won't be out measuring dealerships or trying to go through people's records. What will happen is when we get some kind of indication that there's the potential that they are getting unbalanced, we will issue them these requests. So subpart A, within 15 days of receipt of the written request, provide certification to the commission or its agent certifying that the space used by the motor vehicle dealer or recreational vehicle dealer and the space used by the additional business are in compliance with Tennessee Code Annotated 5517-129. This certification shall be completed on a form approved by the commission if any such form exists at the time of request. So we're envisioning here, basically we're going to ask the dealership to give us a certification, so they'll have to sign their name to it, attesting that they are within these parameters, and it'll be on a form. We're envisioning a form that legal and staff will work together to create. Obviously, we'll bring to you for the full commission for its review and approval. And on there, we'll have space where they can write down the actual area used by each of the dealership and the additional place of business. And, of course, they'll sign their name to that. So if we were to find out that they signed their names to that, gave us false numbers, we would be able to use, for example, maybe some of our other statutes, perhaps penalize them for giving us that false information. Then subpart B, and this will deal with the income portion of the statute. Within 30 days of receipt of written request, provide certification to the commission or its agent certifying that gross income of the motor vehicle dealer or recreational vehicle dealer and the gross income of the additional business are in compliance with TCA 5517-129. The certification shall be completed on a form approved by the commission if any such form exists at the time of request. In addition to the certification, the motor vehicle dealer or recreational vehicle dealer shall provide proof satisfactory to the commission of the claimed gross income or the dealership and income of the additional business. This may include, but is not limited to, past financial statements, current financial statements, and CPA audits. So similar to the previous section, when we issue the request, we'll have a form already set aside that the dealer will sign his name to, stating that they are in compliance. And in addition, we're asking that them provide us proof that'll be satisfactory to the commission. So in these situations, we'd be able to bring you that proof if we have additional concerns, and then at that point the commission could debate whether or not they're within that 6633 distinction as far as income. And we could say this proof is sufficient, or we could turn around and say the proof you provide is not sufficient to the commission, we're going to need something else. We list a few things that we think would be sufficient: past financial statements, current financial statements, and CPA audits. Obviously, a CPA audit is pretty expensive, so we don't want to just force the dealership to go to a CPA audit. So we're giving them a couple of different ways they can provide it. And the rule says no, includes but is not limited to. So if the dealership has some alternative means of showing us the income for the dealership and the additional place of business, we're happy to look at that and consider it and see if we think it meets the criteria we need. Then the final part, subpart C, The commission may discipline a licensee up to and including suspension or revocation for a licensee's failure to comply with subparagraphs A and B above. So I know in the past, sometimes on rule violations, a question has come up whether or not we have the authority to suspend or revoke them on a mere rule violation. So this subpart would make it explicit that if you are not within the 5517-129 parameters, obviously you want to give them a chance to work with them to get within it, but say they refuse to, we would have the ability to take away their dealer license if we wish to.
By the additional businesses?
I believe it's 34% of the existing place of business is the most they can have, or 33% of the physical existing dealership within the four corners of the dealership.
Has to be owned by one individual.
It's a question we'll probably have to come to at a different point. We've had some discussions on this. I think Tony will weigh in on it.
I think when I read it, it says operated by the dealer. So the statute doesn't actually go into who is the actual owner of it. It doesn't specifically state. Those are two. Legally, an owner and operator are completely separate. And in this department, we've had several different programs who use that terminology between owner and operator a little bit differently. So it's really difficult, Mr. Roberts, really to kind of visualize all the different possibilities as to how this statute could be looked at, because it's quite possible that somebody could, for example, you individually, this is just an example, could own the dealership and then decide to have an ancillary business at the same location and just set up a different LLC, but you own both of them wholly. So I think the way we'd look at that is that we'd go back and say, well, you own both of those individually, but they're separate companies.
Licensee, though, would own both business entities.
Correct. Like in that scenario that I just brought up, that one person would own both of them. But then we would get in the scenario, the what if would be, well, what if on that ancillary business you owned it and then somebody else partially owned that also? Would we be denying? It's not even a licensing requirement, actually. Would we be allowing that or telling somebody that they couldn't have that ancillary business? Because it just says operate. So you could be the dealer who's operating it, but there could be maybe like a silent partner who's not there day to day, who is a partial owner. That's where I see that there's a difficulty drawing a fine line, a distinct line as to who is the actual owner of that ancillary business, because the statute says operate. It doesn't actually indicate ownership.
Entity which would be controlled by an individual were not one license part of that. It would be ineligible for a dealer license. With it, have two people. I don't think that's where this. A business that needs an ancillary, who buy-in or support an existing controlling business, an automobile dealership of some type. For instance, I guess it could be something like that. I don't think the intent is to subdivide a building and subdivide a business to that extent. Where's this language taking us?
Well, I think this language that we were looking at here was trying to address the big issue that Matt brought up, was that in the last meeting we were really trying to address the issue of whether or not the rule was overly burdensome for compliance, because the previous rules that we brought up basically said if anybody is having one of these ancillary businesses, then basically every year they're going to be submitting or periodically submitting financial statements, potentially tax returns and things like that, and it seemed, it was brought up as it was overly burdensome, and there was no passing of that language. So we went back and attempted to make language that basically says, okay, if what we have in front of us, which is is that if the commission can request at any time that they make some sort of certification of their compliance with the rule, but we're not requiring that they make that certification every year or every 2 years upon licensure. It'd really be, as Matt explained, if we felt that there was an issue, then the commission has the ability to move forward and ask them to make this. So, but we didn't address the ownership issue really of it, and we brought it up a little bit in the last meeting as to who would be the, who are the owners of these new companies. But the statute is really silent as to how that's supposed to work, and I think it could get complicated given the different types of business models there are out there. But just with saying that, I will say is that the commission has the authority to interpret the statutes that as they see fit, and so long as it's a reasonable statute, generally the courts aren't going to overturn your on there.
I think Commissioner White's concerns were if a licensed dealer owned another business, ancillary business, writing a separate set of books for the ancillary business versus the main business, which would be the automobile business, would be onerous, create a lot of work. In other words, we could have a 95 and 5 example of revenue, and keeping want to be able to look at this as a dealer that owns a person that owns another business that wants to have a dealership on the side. And I think that are we comfortable that that would be the case? And I would ask the other commissioners if that's the same comfort level, if they would have. This would be a car dealer that owns a second business, not a second business guy that wants to sell cars on the side. Interpret that way, does legal,
right? So
do we have matching interpretations?
Right. So I just need to. It's important for us so that when whatever the resolution comes of it, is that we address that in the rule so that it's clear for everybody trying to comply. Because I would do a worst case scenario is that somebody has an ancillary business that's not of the same ownership, and they operate a business, and here I am in this position where we're telling people they need to shut down a business, and we're doing it not because they're trying to skirt the law, but because it's not clear as to what they're supposed to be doing. So that would be the worst case scenario for us, is because we wouldn't be business friendly at that point in time. We would, there'd be kind of this common idea of like we wish we would have explained that earlier. So I think this is the time to kind of to flesh all of that out. So, because what I hear you all saying is that you would want that dealer who's operating that business, that whatever is that separate business is, that it is under the same ownership as the current licensee. It's just that they're selling items that are not motor vehicles or motor vehicle accessories.
Question, should we have a licensee who adds a business? Operating a convenience market, wants to add car sales to his vehicles.
Right. Yeah, I didn't really envision that would be an issue that we would run up against. I really didn't think of it that way. Say that one more time. Is there a bigger problem?
Seems to me that people owning some business not related to the automobile business is a bigger problem for you than an automobile dealer that owns something ancillary.
Right. So I've had limited experience. The issue hasn't come up so much from my perspective when I've seen it, that we are seeing ancillary businesses that held dealer's license. The examples that I could see, as I believe there was one pawn shop and there was one car wash, and I believe there was one person who was selling carports at a dealership, though I don't think that it was primarily a carport dealership. They just also sold them there. So those are the three examples that I could see where it seemed like the car business was really ancillary, that it was potentially ancillary to it. The way that I've looked at it is it appears that a dealer may want to, the perspective that I had was that a dealer may want to sell additional items at its location to be able to increase the revenue of their business, and those items that they're selling may not be motor vehicles or motor vehicle accessories and parts and things of that nature. I mean, you do bring up a great point. I just haven't seen it a whole lot.
I do think that's what we're getting comfortable with, is it adding a business, not someone adding cars to an existing. Get there, whether you have the chicken and the egg question, I guess, but how do we have a business and you want to add cars to it? You don't have any cars as to it being 66% of the revenue for the business because you haven't sold a car yet.
Right, I think that would be.
Does that take care of itself?
No, I think you'd have to, at some point in time, maybe,
establish the 66% revenue.
They may, I could see you'd probably have the division of the property you could see on the application part on the front end, right? I mean, you'd have to have at least 66% of the physical space being the dealership, being for the sale of cars at the dealership first. That would be your first inclination, where you could probably deny the license on the front end if it was, say, an existing business.
Thank you, Mr. Chairman, members of the committee and staff. Bob Weaver, Tennessee Automotive Association. Appreciate the opportunity to comment. I think it's important to remember the state representative that approached industry with a constituent's problem. It was a used car dealer in a rural county in Middle Tennessee who was also selling prefabricated buildings, small metal buildings, along with his used cars. Was cited for having a second business activity at his car lot. That was the issue. That's the backstory that brought this legislation forward. And certainly Mr. Noble and myself met with this particular legislator who was most courteous to meet with us through the process. What you see that was passed is Public Chapter 322, which now becomes 5517-129. It's important to remember the sequence. The sequence, in my mind, is that in order to apply for a dealership, be a dealer, it has to be your predominant or primary business activity. And under existing rules, you could not have anything other than this. This bill creates an exception to that and says that a dealer can add a second business so long as the second business does not take more than a third of the land mass, the physical space, and that the second business does not exceed a third of the gross revenue of that entity. Now, could the statute be worded clearer? I don't know of a single perfect statute that's out there, but the intent of the state representative who is behind this bill was to accommodate that small business person who wanted to add a second ancillary business to his dealership. And it's important. The dealership came first. This isn't a chicken and egg. The dealership is first, and he wants to add a second business. It's absolutely clear in my mind that in the legislative intent was to allow the dealer to add a second business that he owned to his car dealership to qualify for the exemption or the carve-out that's embodied in 5517-129. And if this commission so desired, I'd be glad to provide a statement from the sponsor of the legislation as to his intent. But but it is, I do hope those comments will be helpful as you all deliberate on this issue. Be glad to try to answer any questions.
That coin, Bob, and have the trailer business there first, or his building small buildings first.
I think that's problematic, just by definition, because you come in with an application for a dealer's license. It's not the primary business activity of the location. Then I think you have to look at those other things, the separate and apart standard and other things, to see can you get a dealer's license under that situation. This legislation took the position that there's an existing dealership, and if the dealer wanted to add a second ancillary business, it had to meet these qualifications in order to be an appropriate use of that dealer license, physical locality, and the gross revenues of the business.
That interpretation in mind, and ask Mr. Landorf too, is that to say that really not a way for someone to add car sales to an existing business, because there is no revenue stream for cars because they haven't sold any yet. So would that mean that this would address allow a dealer to add a business, not car sales?
I think if that's the interpretation, if that's the interpretation that the commission wants to use, and to foreclose somebody with an existing business from being a motor vehicle dealer, then I think it should be clear in the rule that it doesn't allow that. I think it should, because I think that's an interpretation that could be made. I just see that it could be. I just see that it could be problematic if it's not clear in the rule. I think it could be problematic for the commission if somebody had a small business and they were intending to open a car dealership that would, at some point in time in the near future, completely satisfy the revenue issue of 66% of its revenue coming from the dealership. And if the commission denied them, I just see that there would be a potential, risk to a lawsuit for the denial of that license. I think that if your rule clearly stated out that wasn't allowed, that more than likely the courts would side with the commission on its ability to deny the license. But if not, there could be some ambiguity in the reading of the statute, and you could have some potential people out there who attempt to open up a dealership from an existing business, relying on the plain wording of the statute and in an interpretation that probably could be looked at that would allow for a dealership to be open in a current additional business. So I would just say if that's the interpretation you all want, that we just add it into the rule.
Putting myself in the place of someone on the staff that would receive an application. Scenario that I don't know gets translated in an application. I'm worrying too much about. I mean, it's a concern. Am I overcooking it? Mr. Weaver, like a comment.
Mr. Chairman, members of the committee, the written words in the Public Chapter 322 starts with a motor vehicle dealer licensed to sell motor vehicles. So it presupposes a dealer's license exists. May operate one additional business at this dealer's established place of business, semicolon, provided, comma, at least 66% of the dealer's established place of business is used for the sale or service or both of motor vehicles, and that the income derived from the additional business is less than 33% of the gross income of the dealership. The dealer may also install signs at the dealer's established place of business for the purpose of advertising the other business. Now, to me, the literal reading of that presupposes the existence of a dealership that chooses to add a second business. And I know that was the intent of the bill sponsored. Mr. Noble, do you agree with that? I agree. And that's just trying to be as straightforward as I know how to be.
License in additional business.
I clearly understand what he said. The problem I have is if a guy goes in with minimum space for the used car lot, now he wants to start selling dogs or puppies, whatever he wants to do. Are you going to let him do it? He's on the minimums to be a used car dealer, now he wants to be this other too. What are you going to do with that?
Mr. Clayton, was that to me or to staff?
That's to you.
Me? Lucky. I would say that, if he's got the minimums, which is 288 square feet, I guess, a paved lot, signage, phone, what have you, that whatever size that space is, if he chooses to add a second business, that second business could occupy no more than 1/3 of his existing lot, and the second business could generate no more than 1/3 of the gross income of that car lot.
What was your finding? Because you went in with the minimum size for a used car lot.
Yes, sir.
Now you're going to add some business. Now you take away from the used car business. You're
Well,
not
he-
holding to your standard.
No, sir, he still have to have the adequate display space, and he'd still have to have those other requirements. He would have to meet those. So if your inference is, if you've got the bare minimum, you've got the bare number of display spaces for your cars, and you've got the books and records, is there a way to carve out a third to do that? It's possible. I could think of a coffee kiosk inside the store that would be a second business if you wanted to offer gourmet coffee in that minimum space. I think he could probably do that under under 129.
Welcome to our world. We've been.
I think it's a bad rule. Then I would vote against it.
Hey, could that scenario be reversed? Something like that, film station, sell cars on the side. Could you reverse that rule and give 33%?
I think that was the scenario that was brought up earlier, which was you'd have an existing business that wants to add a dealership. I mean, I think you bring up a good issue, which is these questions and the complexities are usually seen at the staff level. With Paula's staff, they usually get them initially, and then field enforcement goes out there and they verify what's on the ground. But I know oftentimes when we license dealerships, there are no cars at that dealership because they don't have a license yet. So oftentimes they're just it's a blank shell, and I see that somebody could have a location and then say, well, we intend to open up a car dealership, and then at this car dealership we're going to sell also this X, Y, and Z is probably the scenario you run into, and then we.
I think the problem is you're lowering your standards so he can do this. So do you want to destroy the control that you have now over used cars so that somebody can move?
6633 statute's already in place. I mean, we can't really do much about the parameters that have been given to us by the state. I mean, our rule doesn't really say what you can and can't do at the location. We just ask that you certify that you're that you're in compliance with the statutes. Really, all that our proposed rule says.
Yeah, and I think what Matt's bringing up is that the rule that we have in front of you is really only addressing part of the issue, and this rule is addressing the issue of how would we find somebody in violation of the rule if we think that their dealership is becoming so de minimis that it's not within compliance of the rule, so that the commission could express its authority, and we have a mechanism for Paula's staff and then for the field enforcement people and for legal to kind of join together and make this determination. That's what we were trying to create in the rule, so that we would have a mechanism by which the dealer is given notice that this is what you have to provide if we think that you're not, passing the rule. But that does presuppose the fact that they're already doing it. The conversation here is who is now allowed to do this and how are you allowed to do it in what scenario? Because you bring up a good point about the 288 square feet. It never crossed my mind.
Well, these things are things that we're having to deal with every day. And the field people are having to deal with this every day. And that's why, giving this some detailed thought and consideration is very important, because you have the field person who is out there that's trying to make some type of interpretation and carry out their duties and responsibilities. You have the staff in the admin office that's looking at the applications and the new applications and trying to make their determinations, or an inspection sheet that came back in from a field person. So the way that we do this and the way that or whatever rules that we implement are very important, because in any direction that you go, we've got some ambiguous areas that we need to address. Now, I will say when this statute first passed was at the same time that we were going through application, redrafting applications. Keep in mind that before this statute passed, the 6633, that you were not allowed to have another business within your established place of business, that it was exclusive to the automobile business. So anything prior to the passage of that would have been out of compliance. We, just timing-wise, as we were going through the applications, we included questions in that application that legal reviewed that ask, are you engaged in any, if you apply new, are you engaged in any other business which is conducted from this establishment? Are you the sole owner? And we kind of vet that out as far as what they certify in that front end in the application process. So outside of something that's been overlooked or missed in some way for years, the continuity of established place of business with a contiguous display lot, all those minimum requirements went right up to the point that this statute went into effect, and those rules in the new application, or that language in the new application, picked up to implement this rule. So we still have the opportunities where individuals are now coming into place that may have been maybe they're a tax service. I think I saw one the other day that was a tax service. You've got product sales and you've got service sales. Service sales are going to take up less square footage. There's all kind of variables to consider, but the statute does allow them to post two separate signs, the dealer to post two separate signs for their businesses. So, and I will yield to Mr. Weaver, but they may be one business today, close all of that up, and then open back up as something else tomorrow and still have the service or the product that they had the day before they became a licensed dealer.
With the application, is the requirement still there for a floor plan diagram or space allocation diagram?
There is. We do not have a diagram requirement because it was not in the rule. It basically has them to certify very much like what this document does, that it constitutes 66%. It's the primary business at that location, and then, but it does not require a diagram or a floor plan for a new applicant. I think that would be something we'd probably have to look at rule for. I think that's kind of the way I was led at the time, I think.
Thank you for your indulgence, Mr. Chairman, members. I would speak in support of the proposed rules in front of you, because I think they give this commission the tools they need to vet these kinds of issues we're discussing. The rule before you, as I understand it, and staff is free to correct me if I'm wrong, it says it empowers the staff on your behalf to seek certification from the licensee that they are in compliance with the statute. And I think you want that. I think you want the ability to have this, if you will, clear to all the licensees that violations of this can subject you to civil penalties and leading up to suspension and revocation for violation of this exception that's created by 5517-129. So I would encourage you all to strongly consider what's been presented to you today. I think it was, in my opinion, they did their best to go back from the last meeting and again provide tools to the staff to vet out just exactly what situations are out there.
Comfortable enough with this, or can we get them comfortable enough with this that this is?
I thought, Mr. Chairman, we've discussed it, last time we discussed it for an hour and a half or 2 hours. We've had this discussion again today, and I don't think anybody in this room still really totally clear. I understand the intent to be able to enforce, but I think there's too many vague opportunities that still leave it open to interpretation. Comfortable with it. So basically, I guess is what I'm saying, because I can see both sides of this thing, and I think a potential dealer and or business person could take both sides of it too. Back to your all's point, I could see where legally he could have wanting to sell automobiles and turn down could possibly have legal recourse.
Well, I always like to be one to try to find a fix for it all. So I'm sitting here kind of thinking about what legal could do to assist, and I will just give this as an offer, is that we could go back and look at the rule and add language into the rule that would, one, indicate that the motor vehicle dealer who is operating this also be the owner of the additional business, and bring what that language would be. And then we could also address any person who's applying for a motor vehicle dealer license who intends to also apply with an additional business, that they provide some kind of a certification on the front end that their additional business will comply with this rule, and maybe even put some kind of a 90-day or 6-month check built into that. That's off the top of my head. That's about the best I could.
What a new used car dealer is going to be, and what an existing one can be, because you're allowing him to shrink the existing one.
Will shrink from the 288 square feet?
Yeah.
I see.
So you could always add.
So it's conflicting rule.
You could add space.
Yeah. If he wants to add space to build his buildings or his widgets, go for it, no problem.
Well, is it necessary to say that we expect minimum standards to be upheld, though? Maybe that just goes unsaid. It's already on it's already a rule. Just need to enforce it. I do find the idea that Mr. Glandorf had about buying the same person to both businesses tighter. I don't know if that's. Else thinks that's helpful. I kind of like that. I begin to like that.
The statute allows them to have separate signs for separate businesses, so there could be two different names, located on there. We were just talking about the common ownership was what brought up earlier. So, so that's what I said earlier, is that I think you all can reasonably provide a reasonable interpretation. If that's what the rule says, that's how the commission would end up interpreting it at the end of the day. And I don't think many people would disturb that if it was in a rule.
I'm calling everybody commissioner today, Mr. Merkel.
I appreciate the promotion.
Asked to speak.
Patrick Merkel of the law firm Cameron Worley in Brentwood. You talked about the interpretation and whether it would apply to an existing dealer who is trying to add this, or whether somebody who did not sell cars and wanted to add the dealership. One of my thoughts was adding just a paragraph at the start of the rule would be defining how you interpret the statute itself. Mr. Weaver gave a very good and detailed explanation, focusing on that first line of the statute that says an existing motor vehicle dealer that wants to state that that you have to have a dealership first in order to fall under this section, or the Motor Vehicle Commission interprets this only applying to existing dealerships, and if you are a non-dealership, you need to go through the process of starting up separate and apart and meeting the main requirements of obtaining a dealer license. That would give clarity to the folks on the front end, and that may kind of help Mr. Commissioner Lee's issues of ending the debate of how it's interpreted. You've stated already how you're going to interpret it, and then and who it applies to.
Yeah, that would satisfy me, because I don't think we have, back to we ever said who it applies to. We're out here everywhere, but I think that would do that.
And that might head off some fights that you have in a contested case hearing, or somebody trying to challenge the interpretation. You've already told them how you interpret it.
If those that are regulated, that we're hearing from now, begin to get comfortable with it, and then almost there if we can get the staff comfortable with it. Do we put Commissioner Lee's comments just in the record as what we interpret it to be, or are we going to we need to go back, author something to that effect? What was yours?
That's what Mr. Merkel said there.
What was yours?
My suggestion was actually start it with a paragraph of the rule stating this is how we interpret it, and that it applies to existing dealerships adding a separate business.
That's what makes everyone comfortable. I think it just gets to the question, is it necessary? Is it necessary for the staff to, and what about interpreting the rule?
I do think it might box you in a little bit if you do that. If you decide you want to change course and you don't like the outcome you're getting, it would require an additional rulemaking to delete that out of the rule. Just something to think about.
We'd be adding, wouldn't we?
If we were to add that in and then we get this rule passed, and then 6 months down the road we see that we don't like how that's working out, it'd be really difficult to just start ignoring that part of the rule. We'd have to go through a whole rulemaking process to then amend this rule to delete that out. As opposed to if we leave that open to the Commission's interpretation when it comes up, it allows you to interpret it one way, and then if you find out maybe it's not interpreting it how you intended it to, you could change your interpretation down the road. I think if you concretely write that into the rule, it's very clear to everybody what's happening, but you've also pigeonholed yourself into that interpretation. So something that maybe consider.
What would be the negative outcomes of doing that?
Well, we're talking about we only want a dealership to be able to add an additional business. I'm sure, as we mentioned, it's conceivable that additional business might want to add a dealership, and maybe they formulate a really strong reason why they should be able to, and they get an ear of their representative, and it turns into an issue because we're not letting that gas station build on and add a dealership onto their gas station. And then we're looking back on this that, under the rule, we clearly can't allow them to do that. Someone's come down here and made an argument, and all of a sudden we see there might be situations where we do want to allow them to add a dealership, but we can no longer do that under the rule. I think
And the committee, in layperson's terms, in our language, express what we think the interpretation of this.
I think you probably want the full commission to express the interpretation of it.
Say it first, and then it be voted
Yeah.
by the full commission. Is that a way to get there?
Yeah, I think that's this process is what it would be, is that the committee's authorized to come up with the rules that would express the interpretation, and the full commission has the ability. Yeah, the full commission would be the one that would make the final decision on the rules, which would solidify the interpretation. Everything's done in the committee anyway, so this is the place to kind of express that. Matt's really bringing up the point of, is that somebody who legitimately has like a service station that now wants to add a dealership to it, and or not just a service station, like a gas station, and then we end up telling them, no, because in this scenario, Paula would come to us and we would have some concern, and we would say, okay, we all agree under the way that the rules are written, no, we will not allow this, and we would be denying the license. But so long as it's clear in the rule, we're comfortable doing that. I think that there is, when I read it, and if that's the way the interpretation is, that's just the way it is. But I do see the scenario that somebody could get around the rule by, or just say, I'm now in compliance with the rule, if they apply for a dealership license and they get a license on Monday, and then on Tuesday they're bringing in the additional business. However they want to do it. So, and then saying, we didn't have to get permission, we're just in compliance. It may have been their intention the whole time of really having kind of this additional business, and so long as it meets the requirements, I don't think there's generally a problem with that. I think what Mr. Clayton has brought up is that somebody may have an additional business and it becomes a dealership, and it may not be of the level of dealership that everybody else has made to the standard.
I think that
and we wouldn't be able to test that really for a while until there is some revenue.
That's right. You wouldn't, but you put the same pressure on the guy that wants to start a new used car lot, and I think as long as he meets the guidelines of a used car store now, then when he adds them, he should still meet that same standard. I don't believe it should be allowed to change the standard. That's my argument.
The 288 square feet?
Yeah.
I'm not so sure. It almost looks like as if somebody was an existing dealer with only 288 square feet, that the statute would allow them to use a third of that 288 square feet for that additional business.
We're confronting this, we're dealing with this every day now, and it's a new application or existing. New application has to disclose and make those determinations with the statute. That comes in on the application. If an existing business makes a change and adds that secondary business, that's usually detected during inspection. And so we're dealing with it on the inspection aspect of it. But if you had the certifications on the front end, you had the mechanisms that legal has proposed on the back end for that existing business that has changed its business model after it got a license, and you go and there's one car and 15 mobile homes. You can address it through that. I feel pretty comfortable if we addressed it from the new and existing. Newly applying dealer would fall into this category, and in the existing ones.
I don't think it allows for, reading it again, I'm not sure, allows for a dealer to apply, that's not existing dealer, to apply for 6633 division of businesses. Are we getting to the point yet where we interpret this as a licensed dealer that wants to add another business to an existing business, and it still has to meet the minimum requirements dealership? Are we getting there yet? If we get there, maybe they don't need to write anything else. Let's just go with what we got.
Well, just some examples that we see, and it's not uncommon. We had one last week before, which was a hair salon. It was either the hair salon first or the car lot first, and it may come, the chicken or the egg, either one may come first. And sometimes it will be a sole ownership, or it'll be a husband-wife ownership, or they'll have extra little space of the building that they want to rent out, but they're sharing a common bathroom. Those are all scenarios that we're dealing with every day. So it could be that. It could be the one that we brought before the commission that was like a flea market type scenario, I think Matt presented. So we're seeing many variations.
Mr. Chairman, committee members and staff, only thing I would also, just for your thought process, is every time an entity licensed by the Motor Vehicle Commission renews, applies for a license, they agree that they will conform and comply with all the laws, rules, and regulations of the Tennessee Motor Vehicle Commission. So if you had that existing dealer that added something before the passage of this act, when they renew their next license, the statute clearly says they have to be in compliance with all rules and regulations. So just for what it's worth, every 2 years it catches up.
What are our instructions, if any?
Else, then maybe you don't even need this control. So if you're going to size for an existing dealer, then I think you're doing it wrong. I think he should be treated as I do not oppose the second business. I don't oppose that at all. But oppose is the mobile home lot dealer down here that doesn't have the adequate space. He goes into the used car business, or vice versa. And you allow him to use the same space that he's qualified to use for the used car lot. That's my argument there. It is a used car lot by the statutes that you want to establish, or it isn't. And if you're going to allow him to use that same space for some other business, then it isn't.
Kind of agree with that, especially when I was irritating my mind with hairdressers. I can see that all of a sudden our business gets bigger. She puts in more chairs, and all of a sudden now, 288 is down to 200 or whatever. I've got a used car operation, and I'm running a little coffee thing out of mine. At his hairdressers down there. I mean, I can see.
He's got extra land, so be it. That's
He
good.
wants to
That's
expand.
good.
Yeah.
Well, is that to say we're not comfortable with that, with this all enforcing minimum requirements? Do we think what we see here makes leaves an out on minimum requirements?
Have your minimum requirements.
I don't think they would go anywhere as a result of this law. I think they're still in place. What do you think about the minimum requirements?
Well, if it goes back to the existing, I think that's got everything covered. Yeah, I'm looking at it wrong.
Does the staff feel like minimum requirements would still be in place even if an existing business were to be, the desire to add a business to the existing business?
I think it'd be reasonable for you to ask us to include some kind of phrase, something along the lines of the area used by motor vehicle dealer shall meet minimum facility requirements independently, something along those lines.
Well, maybe this ain't, I mean, if I go back and read this, a motor vehicle dealer licensed. To get licensed, you got to have the minimum, right? May operate one additional business at the dealer's established place of business, which is at 288 square feet.
Plus that, there's a definition for established place of business.
What's that?
The definition for the established place of business means a permanent structure or structures owned, leased, or rented by a motor vehicle dealer providing signs, facilities, and office space used exclusively for buying, selling, displaying, advertising, demonstrating, servicing, or repairing motor vehicles, or functional or non-functional parts of motor vehicles, and where replacement parts, repair tools, and equipment, as well as the books and records needed to conduct the business are kept. The structure or structures must be physically apart from any other business and shall not include a private residence of any sort, tent, or temporary stand. And I believe that's why it says the additional business is because it's an additional business at the established place of business. So, right, it does say it in there, so it's an exemption to that, because I've always looked at the established place of business as not just your office, but it's also your parking lot and it's the entire physical location that we're licensing has always been the established place of business. And then within there is your required minimum office space of 288 square feet. Am I right? Is that how you see it, Paula?
Yeah, the 288 square feet is based on interpretations, and I think there's actually rules.
Set by rule.
Set by rule in historically, which is an interpretation off of what you just read. And then you have the 15 parking spaces and the 3 parking spaces. This is on your minimum requirements for the minimal auto dealer location. It doesn't say how many cars you have to have on those spaces, which is where we run into kind of the debate with some of the applicants, is they'll say, I'm not going to have more than 3 cars at one time, so I want to use this space for something else.
Isn't this saying out of that 288 that only 66% of that has to be used for motor vehicles?
What it really says is that it's of the established place of business, and so the established place of business, if you think about it, it's the physical total location of the dealership, and that your office space is just a small part, because the rule doesn't just require 288 square feet. It's that certain parking spaces for the cars and then for the customers, so it's the whole thing. So I think we've kind of run into another issue where there really wasn't a lot of kind of thought coming into this meeting as to the physical space requirements, because I honestly thought of Mr. Weaver's example that he gave as to why the legislator came up with this statutory change was it appears that they were selling like other type buildings on the location, and it may be that office space, there's really not a delineation within that office space as to what they're doing. They're just, if it's owned and operated by the same dealer, it may be on the same the same books or whatnot. They may be using the same people.
I've got a guy that's beside me that's got a mobile office. He sells cars on the front and he sells prefab buildings on the back. Those prefab buildings are twice the size of a car, and they're taking more than 33% of this guy's business right now. I mean, it's about 50-50 if I'm just guessing when I look at it. So,
yeah.
Actually, he just got his license 3 or 4 months ago.
Yeah, that may be one that doesn't comply with the physical space requirement. Yeah.
And I think just listen, and I'm just throwing this out here for discussion purposes, what I've heard is 4 different things that you've kind of focused on, and one would be if we looked at the possibility of tweaking up the language a little more to add and specify the Commission's interpretation of the statute, which was one suggestion. And the second would be adding language that would certify that they were in compliance at renewal time, which is taking in another...
That's already in the statute.
Yeah. Okay. But we could, as far as if we had a concern with the 6633 or it's the primary established place of business is auto sales, that could be used in the language. And then the other concern that I heard was that the second business should not interfere with the minimum requirements that are required for a dealer's license, the 288 square feet, the 15 display spaces, the 3 for the parking spaces, that it would not in any way interfere with that if it's in addition to. And I'm just stating the concerns I've heard. And then the third thing fourth thing that I heard that I think could add some clarification, but I don't know how everybody feels about this, is if there were a floor plan, a diagram, either with the application or if, when we went through the certification or request the certification process, that they were required to submit a square footage floor plan that would become part of the permanent record. So the person that you're referring to, Commissioner Lee, that now looks like they're 50-50, they could have been 66-33 when they applied, and now it's encroaching over onto the other part. But still, you run it, there's still a little bit of vagueness in, if a person just has the 15 spaces, let's say they opened up with 25 spaces, and then they start moving over. They can still meet the minimum requirements, but it appears that it's encroaching if you're not real careful with the way you interpret that. Those are the four things that I heard.
Well, could we knock one of these concerns out with a phrase that says in the, long as minimum dealer requirements are being. Other, I do like the diagram thing. I don't know how we enforce the space part of this without a diagram, but I don't know if we want to.
I think that'd be easy enough to add.
That, Tony? As long as we.
Oh,
I guess, can we try?
Well, like I said, you kind of hit the nail on the head with what I usually say is we can try to do that. We can argue it. We can say, this is how the commission feels is that the minimum requirements for the dealership office space and its parking lot, its customer service shouldn't be disturbed by this. And
I might kind of excuse my rudeness, but if we were to say continues to meet, I think there's a as long as the minimum requirements are continued to be met.
Well, I say that I don't know. Sometimes it's difficult to kind of make a decision or really give really sound legal advice kind of on the fly. But I think what my initial reaction is thinking is that it mentions established place of business, and established place of business is everything, and it's 6633, and it just brings that up. So I think it may be possible that the commission can create an interpretation that would say overall established place of business, but then these certain things can't be disturbed. And it would be ultimately up to the Attorney General's office, who we give the rules to, and determine whether or not you all have the authority to do that. There's multiple checks, and then I have to go to the Government Operations Committee, meet with the legislators, and kind of explain it to them also. So there's
somehow to say you can add a business, but you have to maintain the minimum.
Explore that. I'm always concerned, like, what are we missing, though? Is there something else that we potentially could be missing in all of this? But I think we can, if we said that, and of course, if somebody had greater than 288 square feet, then that would work. I mean, the first inclination I worry about is, like, what if somebody does have on the back of their parking lot some mobile homes, and let's just say it doesn't breach the 1/3 of the physical space out there, but they're using the same secretary in their office of 288 square feet. And then we came back and say, well, this isn't 288 isn't dedicated just to the dealership. You're also, taking payments on that out there. Would we say that the 24 square feet that she encompasses, is in violation of the rule because she's doing both? I mean, because I think maybe you're running into that more often than not. It may not be the coffee shop scenario. It may be the scenario where you just have, a building with 288 square feet, and they're just doing the purchase transactions and all the inventories out there on the lot, and they're fine with that physical space, but could they use the same walk-in door location to run the credit card? I mean, that's where those are the kind of questions that staff get asked. It's the hard questions. It's not the easy ones, but these are the ones that usually come up to us with legal, and with all those people we usually try to get together in a room and try to decide what is the what work with the rules that we have.
I think you will run into, I mean, this is not a perfect world, but your county and city business tax and your state sales tax receipts are going to show what you've had wholesale or you've designated as one business type over another business type. If we got to that point where they had to certify that back to us, if they break it out properly, as they should, then you're going to be able to see how those gross receipts are reported in those documents. That doesn't, necessarily take care of your floor plan or your footprint of the physical establishment itself, but it does, between looking at what those minimum requirements are, the 288 square feet and the parking display capability and their gross receipts, there's a certain degree of reasonable assurance you should be able to get as to whether or not they're in compliance. And if they're that close to making a determination, nobody's probably going to bother them anyway. I mean, it's going to be the one that has one car and 45 mobile homes sitting there that's going to bring an issue.
Well, we can, legal can take all these suggestions and come back and try to have language that's, drafted, to kind of shore this up. If you all are comfortable with the current language that we have, we may be able to address that, but.
I'm not even sure now that this rule will allow a dealer to have less minimum standard for space, not minimum standards for dealer license.
Mr. Chairman, for what it's worth, these rules that were brought to you were an attempt to give staff the tools to try to find out the answers to some of these questions, the way I look at them, because they're asking for certification of the numbers, and I think they'll ask for certification perhaps with the physical layout. I do think, and I continue to think, I have to go back to what the representative's intent was. And his intent was he had a used car dealer in a rural county that wanted to sell these metal buildings at his car lot. He was doing it. He got cited for it. He was in violation of the exclusive place of business standard. And so his intent was to allow his constituent to continue doing what he was doing, and he assured Mr. Noble and myself his intent was not to undo the car law or not to hurt car dealers in the process. But in the legislative discussion, there was not a lot of discussion. There were several comments made. Well, why should they have any constraints on them? Why can't they sell whatever they want to sell in addition to this? And this representative, to his credit, tried to honor our conversations that he had with Mr. Noble and myself not to do damage to the car business. And so whether I personally have not visited the car lot in question, Mr. Noble has, whether or not it's 288 square feet, which is a rule of this Motor Vehicle Commission. It's not in statute. That's a number that was put in place many, many years ago. Is it right? Is it wrong? It's anybody's guess. I would hesitate to put something in the rule that would cause uncomfortable questions being asked the Government Operations Committee. What is your justification for 288 square feet? Why is that number so important versus 280? What we're trying to do is allow this small business to add this ancillary product as long as it doesn't exceed a third of his business model. The statute's there, whether we agree with it or we don't. The statute's there. So what does the staff need? Well, what I'm hearing the staff need is they need the ability to go to these licensees and say, an exception requires the person receiving the exception to prove their right to the exception. Now, that's stated rather awkwardly, but that's true in tax law, and it's true in licensing law, in my opinion. So you've got the general statute that has to be exclusive, and then you've got 129 that says you can have this 6633. You can have this one additional business if you conform. What they've asked for you today is the ability to quantify their ability to continue to receive the exception. And I do firmly believe that in the sponsor's mind and in our minds, when we left those meetings, hearings, floor votes, whatever, his concern was for that individual could add one more business to his existing car business if he conformed in the way that was agreed upon. So I would encourage you to try to honor that legislative intent in your discussions and your deliberations.
Elaborate further on this? Can we get it any better? Is this a good product? I don't think that there's a lot of doubt as to what would like to see take place, and it seems to match up to me. Talking about going to the same place, is just how we get there. Is that where we are? Can we call this a product and move on? Is anyone just really uncomfortable with the rule?
I'm not opposed to the rule. I just think pretty confusing right now what is required. The size of a used car lot is required. The 288 feet for the same cover. Then you got parking spaces out there that you got to park cars. Now you got spaces you got customers. And I believe there's an older city ordinance. I suspect there's state too on how many parking spaces you've got to have.
And they'll have a zoning letter for that, and that's in rules, so that will be addressed.
Yeah. So
What if you have more than
those
one
factors.
dealer wanting to be in the same establishment? We're having that question as well.
Yeah.
Just throw that in, make your head spin.
Well, is there any?
Maybe it all needs to be visited, really.
Director Shaw, do you think there, as written, is there anything caused angst for the commission or specifically Clayton as to whether or not minimum requirements would be waived?
I think this is a really good starting point because whatever it is, it's a long way from where we are right now. So I think that this is a topic that we're probably going to discuss more as time passes. I do like the idea of a diagram or footprint for the file, because when these scenarios come up in the future, you have something that is very affirmative about what they stated when they originally licensed, or when they had to answer the request to show that they're certified. I think that addition would make it a little easier for us and for the commission to evaluate when there was a question.
Would we need a rule to authorize the staff to require a diagram of space allocation on an application?
If they didn't turn in the diagram and you were going to deny them for the application not being complete, I would say that the commission only has to approve the application and not a specific rule on it. I believe that's, and I'm looking at Matt over here too, is that yes, the statute says that you can approve the application. So long as the diagram is a part of an application, then yes, you can do that. You don't need a rule on that. It can be part of the application, which is just the entire commission voting on it. Yeah.
I think somebody can include on the form too.
Form itself for them to approve. I think it's progress.
Commissioner Clayton, you getting warm and fuzzy yet about the space allocation?
I stated what my opinion is. If you're saying going in that it's 288 square feet plus whatever these other items that I don't know what are, because every car lot I've got's got more space than is required, significantly more, most of them. So, but what I'm concerned with is these dealers that are setting up out there that it's a junky place, and cars are parked every way, and then they try to sell some other things on the side, and that's alarming to the whole industry when you get there. So if you're going to be in the used car business, I think you need so much space to do business. If that qualifies, okay. If you're saying it's 288 square feet, less a third, then that's what it is. But I ought to be able to go start one with that same space, not giving up space. Whatever the minimum is, it should stay the minimum.
If the staff has
for that business,
if a staff feels so uneasy or undecided about approving an application with a second business added to it, staff always bring that to the commission to out of the 288. I mean, if it's 270 feet, can the commission license?
I don't understand the two reasons there.
I'm under the understanding policies and procedures, and then anything that varies from that they bring to the commission, and the commission. Is that what legal thinks? Is that what the staff thinks? If that's the case, just stick to the minimum requirements, and if you see one that is justified or that applicant wants to appeal that, I guess you can appeal an application.
I would
trust
buy
all the
that.
people in the commission to make a good decision.
Yeah, I would agree with that. In this case,
We're going to make it work.
Public comment?
I just still come at it from the standpoint that I know his intent, and I know the intent of the independent dealers and ourselves was that this was an exception to assist an existing dealer. And I keep coming back on that because I think it's paramount to this whole discussion that you start out with an existing dealership who wants to add an ancillary business, not an ancillary business that has no license from the Motor Vehicle Commission, then wanting to apply for a dealer's license. I don't think that qualifies.
Hey, and I know I'm not up to speed on all of this, but if you take what Bob just said, that this is an exceptional case, I can accept that. My question is, though, if somebody's got a lot here, be it a drugstore, be it an ice cream place, whatever, they want to add a car business, what space do they have to have? Do they have to have more space than is cultivated into this one, this special one? That's so it seems to me that it should be one size fits all.
Well, going back into your scenario, I think that it has to be an existing. The same thing. I'm on the same page with you, but I think that it's addressed. License, which would be existing.
I can accept the fact that the commission could override that. I can accept that. But you don't want everybody encroaching on this issue all across town.
Oh, no, we're in agreement there. Back to
Cut them both off.
Mr. Noble would like to be heard.
Darrell Noble, Tennessee Independent Auto Dealer Association. Hoping Bob could get through all this because he and I had the same discussions with State Representative Pody, who wrote this bill, and we were informed that we didn't want to change the used car business or the footprint of the used car business or the new car business, because this bill is not just for used car dealers, it's for new car dealers too. You can add a rental car company in your store, and that's another business, and that's what it's designed for. But it still has to put in place that, and this is how I interpret it as an association, this is how I interpret it as a used car dealer myself, that you must be a dealer first, and then you must have the facility and the area to run another business without superseding what you already been put in place by the Motor Vehicle Commission. I've only had just a few people ask me about this bill, and that's how I've told them that we perceive the bill, is that you must be a used car dealer, you can run another business that you own, and you have to have the adequate space to do that, but not let that business overtake this. So in the case of somebody that had 10 or 12 big mobile homes on there and a couple of used cars, they obviously would not be in compliant with the 6633 rule, and that would be very easy for an investigator to check. No way do I perceive this bill that you could be a convenience store and decide you want to put in a used car lot, okay, because it says you have to be a dealer first and then secondary business second. So with that in place, then the dealer's got to be that guy, and there's no other way for him to get around that law. And like Mr. Weaver said, every 2 years we're going to be inspected. Every dealer's inspected. So when the inspector comes in and he perceives or he sees that it's not what it's supposed to be, then he's going to take action at that point. And I don't think we've had any of that action yet. Maybe we have. But a lot of the inspectors that I've talked to throughout the state when I travel aren't even really 100% up on what this bill is, because they haven't come across a lot of it. We don't go out and publicize. I don't tell dealers, hey guys, go put another business in. Let's just try to keep it dealer business is what we're trying to do. I think the bill was wrote with the intent to keep the automobile industry the way it is, but give a small dealer or any dealer an opportunity to bring in some other revenue. But I clearly see this. You have to be a dealer first. Okay? Thank you.
Don't we leave the rule as it is? Probably need in its report to make some type of statement to the full commission. Possible just to someone add narrative to it. It would probably be better if it were voted upon or approved by the committee to accompany that, because we're not going to just read this rule and say vote for the rule. If we say to the full commission that guidelines of minimum requirements. Requirements for, I don't know, we have to say that, an existing dealer, that does for licensee, and
I think what you're saying is if we go to the full committee and
Chairman, I move we'd move it, that we take it to the full commission.
motion to take it to the full commission as is. Okay. All right. Discussion, but I will allow it, and let's have a roll call vote.
Chairman Roberts. Commissioner Clayton.
Yes.
Commissioner Fox. Commissioner Lee. Motion carries.
Other business, I don't believe.
Legal doesn't have anything further.
Is there a motion to adjourn?
so moved.
Second. It's unanimous in the audience. We're adjourned.
Commissioner Roberts?
Yes.
Sorry, did you, real quick, do we want this under inspection?